Welcome to this special meeting of the Ethics Commission. We will begin by taking the roll. Commissioner Studley.
Here.
Commissioner Liu.
Here.
Commissioner Hayon.
Here.
Commissioner Rennie.
Here.
All members of the Commission are present. We are here to conduct the evidentiary hearing relating to the official misconduct charges that were instituted by the mayor against the sheriff. A couple of things I'd like to announce before we begin discussing the evidentiary objections that were submitted by the parties. The first is that because this is going to be one continuous hearing, we will not be taking public comment today. We'll be taking public comment at the end of the evidentiary portion of the hearing based on which witnesses are called to testify, which experts are included. The evidentiary portion of the hearing could be over as early as June 29th, although again, it depends in large part on how the evidence comes in and which witnesses are actually called to testify. Second issue I'd like to raise is one that was raised at the last hearing. We appreciate the public's attendance at this hearing. I think it's important that the public is here, and we certainly welcome the public to be here. That said, we are trying to conduct a hearing that is we're required to conduct under the charter. And as a result, if we could keep comments and any noises from the crowd to a minimum, we'd appreciate it. We have law enforcement here to help us in that regard, but I hope that it will not be an issue today. First thing I'd like to address are the sheriff's objections to the mayor's witness declarations. The mayor submitted a number of declarations. To me, I think we may be able to handle this most efficiently if we actually start with the declaration of Vicki Hennessy. Because in my view, what happens with respect to Vicki Hennessy could affect how much of the other declarations we actually need in this case. Given that the sheriff has submitted his objections, I'd invite the mayor to respond to the objections that were propounded with respect to Vicki Hennessy.
Thank you, Commissioners. Sherry Kaiser, appearing for the mayor. Oh, thank you. Is that better? Sherry Kaiser, appearing for the mayor. Honestly, I'm a bit at a loss to address the objections to the declaration of Sheriff Hennessy because the declaration is that the duties and powers of the sheriff as contained in this declaration are all irrelevant. And I don't understand that objection because one of the elements that we have to prove is that the misconduct occurred in relation to the duties of office. And in order to do that, we need to provide evidence to you of what the duties of office actually consist of. And the acting sheriff certainly has a foundation and the knowledge to tell you what the duties of the office of sheriff are. And I believe, unless you or Sheriff Mirkarimi has questions, that the declaration is fairly limited to an explanation of what those duties are, how the office functions, and also standards of professional conduct for the sheriff as the sheriff understands them to be a duty of her office.
Questions from the commissioners for Ms. Kaiser? Mr. Kopp or Mr. Wagner, do you have a response?
Yes. Good evening, Commissioners. Our objection to the majority of the declaration by Acting Sheriff Vicki Hennessy is founded on the fact that we have a very different view of what the duties of the sheriff are than the mayor appears to have. And we take more of a literalist or a strict constructionist approach, and we think that the duties of the sheriff are those spelled out in the charter, and that's why we didn't object to that portion of her declaration, and that most of the rest of what Acting Sheriff Hennessy has to tell you is really going to be irrelevant to your determination of whether or not what he is charged with doing constitutes official misconduct and is related to those specific duties enumerated under the charter. Much of the rest of this is an encrustation or an enlargement of those core duties. So that's the basis for our objection.
Any questions for Mr. Kopp from the commissioners? Thank you, Mr. Kopp.
Thank you.
May I respond?
No. I think that I understand that the parties have a different view on whether and to what degree the actions in this case have to relate to the sheriff's duties. But I do think that given that there is a legal dispute about that and that the declaration of Vicki Hennessy does purport to relate to the duties of the sheriff, that the declaration of Vicki Hennessy should be admitted and that the sheriff should be given an opportunity to cross-examine if he so chooses. I welcome the thoughts of my fellow commissioners with respect to the Hennessy Declaration. Commissioner Liu?
I agree that the job duties of the sheriff are at issue, and so it seems like both parties are in agreement that that is at issue, and so whether we have competing and differing facts about that, I think that that is relevant and that should come in.
Any dissenting view as to the admissibility of Vicki Hennessy's declaration? Okay, like we did last time, I think what we should do is not take a vote on every one of these, but at the end we will take a vote on all the decisions that we're making. And I would ask either Ms. Ng or Mr. Embledge to help us keep track of what specific decisions we've made. Okay, next I would like to go to...
Mr. Chairman?
Yes.
It seems to me it probably would be better if we did, for example, I think there's no objection by any members of the commission to the introduction of the interim sheriff Hennessy, to go on record at that point, because the problem of trying to, we've got an awful lot of these we're going to have tonight, and some may get lost. And I think if there isn't any objection, or if we agree with your ruling, I would prefer that we indicate on the record that there was no objection.
Any dissenting view to that? Okay, I'm happy to do that. Is there a motion to admit the declaration and exhibits of Vicki Hennessy?
So moved.
Second?
Second.
All in favor?
Aye.
Opposed? The motion passes. Next, I think we should address the declaration of Paul Henderson. Ms. Kaiser or Mr. Keith, would you like to, do you have anything to say?
Yes, thank you, Commissioner. Once again, this declaration has been objected to in its entirety on relevance grounds, and I suspect that the issues are similar to the last declaration that we just covered, but again, there was no explanation of what the relevance objection was exactly. Mr. Henderson's declaration goes to city operations, of which the Sheriff's Department is a part. It goes to the city's efforts to combat domestic violence and how city agencies have collaborated in that effort together and with the community. And it explains that the sheriff has a duty and a responsibility in regard to that citywide work. And it concludes with the factual observation that community members, domestic violence advocates who are working directly with Deputy Chief of Staff Henderson and are informing him directly of their efforts are no longer willing to work with the sheriff if Ross Mirkarimi is at the table because of the incidents that are under consideration by the commission. I believe that that is once again relevant to the duties of the sheriff's office. It may be that Sheriff Mirkarimi does not agree that collaborating with other agencies or the community in the way that has taken place so far is one of the duties of the sheriff's office, but this is evidence that it is, and I think it is relevant for that reason. Even if the commission finds to the contrary, this evidence is relevant. As for the final 3 paragraphs, which are objected to as speculative, lacking foundation, and purporting to be an opinion, they're actually not speculative. They're a recitation of the facts that Mr. Henderson has learned in his official capacity as the Director of Public Safety Issues for the Mayor's Office. And they also recite the conclusions from a number of city reports that have been generated as official city documents about the ways in which combating domestic violence in San Francisco can be successful or can fail.
Thank you, Ms. Kaiser. Any questions for Ms. Kaiser from the commission? Would someone from the sheriff's team like to respond?
Yes, please.
Mr. Kopp.
Thank you. To enlarge on our objection, again, this is part of the mayor's effort to expand the duties of the sheriff, and the reason for that is clear. It's because it makes it easier for the mayor to prove his case. But the problem that we have, particularly with this declaration by Mr. Henderson, is he's telling you about these fundamental responsibilities that the sheriff has that are nowhere to be found in the charter. And so that's the reason why we object that there isn't a foundation for this. Mr. Henderson wants to tell you that the sheriff has to convey to the public that domestic violence is a serious matter of public concern that is never acceptable. Well, maybe he does and maybe he doesn't. I'm not saying that Sheriff Mirkarimi would ever say that it wasn't a serious matter, but if a sheriff were to take office and not come right out or at any time during his tenure, his or her tenure, and say domestic violence is a serious issue that has to be taken seriously, I'm pretty sure that sheriff would not be subject to removal from office for violation of his official duty. And that's the problem with this declaration, that it purports to add to the actual duties of the sheriff, and I think in a clearly improper way. And so those are the bases for our objections.
Any questions for Mr. Kopp? Thank you, Mr. Kopp. My view on Mr. Henderson's declaration is that while very informative, I don't think it's relevant to what the task that we have. He is not in a position to tell us what the duties are of the sheriff. And I think to the extent we need to know those duties, we can get them from the sheriff or from Vicki Hennessy. So I am inclined to sustain the objection to Mr. Henderson's declaration. With respect to the objections to paragraphs 16 through 18, I agree with the relevance objection. I also agree with the foundational objection to paragraphs 17 and 18. Welcome the views of my fellow commissioners with respect to the declaration of Paul Henderson.
I would move that we not admit the declaration of Paul Henderson.
Is there a second? Second. All in favor?
Aye.
Aye. Opposed? There being none, the motion passes. The declaration of Paul Henderson will be excluded from evidence. The next declaration is the declaration of Wendy Still. Ms. Kaiser, would you like to address that?
Yes, please. Thank you, Commissioner. I would like to offer to the Commission that to the extent foundational objections are being offered, one way that we can address those is by having the witness testify and explain to you what the foundation is, and that's often the case in court, that it can be handled like that. So I suggest that as an alternate strategy for resolution on foundation issues. In terms of the declaration of Chief Probation Officer Wendy Still, she again has testimony of direct relevance. She again can offer testimony about Sheriff Mirkarimi and his probation in particular, which is part of our showing of misconduct, or gosh, the term is escaping me. I'm sorry. I was going to quote the actual words. But in any event, she can provide evidence of that. She also provides evidence of the relationship between that misconduct and the duties of the sheriff, not just any sheriff, but Sheriff Mirkarimi, who will be reporting to her as a probationer if he remains in office, and as he already is. But he will also be sitting at the table with her in terms of collaborating on important fundamental policy matters like realignment, and other issues that affect multiple criminal justice agencies. With due respect, the mayor retains the position that the sheriff is not an island and does have duties to cooperate and collaborate with other city agencies. Adult probation is one of them, and it's actually a very important collaborative role. It is then the mayor's view that both the duties of the sheriff and the information about probation that are contained in Ms. Still's declaration are relevant and admissible.
Thank you, Ms. Kaiser. Any questions for Ms. Kaiser from the Commission? Mr. Kopp or Mr. Wagner?
Thank you. Once again, I'm going to probably do this more than once. I'm trying to focus the Commission's attention on what we think are the real issues here. And the real issues are not whether or not there's going to be a difficulty presented by having a sheriff on domestic violence probation, because that really doesn't relate at all to the inquiry. Is this official misconduct? So, again, for many of the same reasons that we argued against the admission of Mr. Henderson's declaration, we don't think that this sheds any light on the issues that you've got to decide. And for that reason, other than the portions that we agree are relevant, paragraphs 19 through 22 in the specified exhibits, we don't think this should come into evidence.
Questions for Mr. Kopp?
Yeah, Mr. Kopp, is it your position that the fact that the sheriff would be on probation during the time that he's in office is irrelevant to the question of whether or not the mayor acted properly in saying he couldn't carry out the duties of sheriff?
Well, I think I would have to answer by saying that I take issue with one of the premises of the question, because the inquiry is not, could he fulfill the duties of sheriff? I don't think that's what the Commission needs to decide or should decide. I think the inquiry is, was what he did official misconduct? I mean, you know, in politics, people may get elected that don't get along with other members of the city power structure, and they may work well together or they may not. And I see this question that you pose in the same light.
Well, my question, though, is that even if you find somebody committed official misconduct, it isn't absolutely necessary that he or she is put out of office. There can be other forms of punishment. We know that's happened, okay? It isn't, so you have to focus on, don't you, the fact that one, is it official misconduct? And if you say yes, it is, does the fact that he committed this act in some way adversely his ability or her ability to carry out the duties of the office? Isn't that an issue?
Well, respectfully, I would answer that no, it's not.
Any other questions for Mr. Kopp? Thank you, Mr. Kopp. My view on Ms. Still is that the objections to paragraph 1 through 18 should be sustained. There being no objection to paragraphs 19 through 22 or exhibits 36 through 41, I think that testimony should be admitted. I am cognizant of the concern that Mr. Rennie and I believe other members of the Commission have voiced about the relevance of the effect that the sheriff's conduct may have on his ability to perform his job being relevant to the inquiry of whether his acts relate to his duties. I think I've expressed the view that I don't think that the consequences of those acts are relevant to whether or not the actions were official misconduct. But given the diversion of views by the Commission previously, I think it would be helpful to admit the first sentence of paragraph 26 and paragraphs 27. I'm sorry. I would admit starting with the second sentence of paragraph 26 and the remainder of paragraph 26 and paragraph 27. So to be clear, my proposal is that we sustain the objection to 1 through 18 and exhibits cited therein, the first sentence of paragraph 26 and paragraph 28. I welcome the views of my fellow commissioners. Ms. Kaiser, if you could please take a seat, and we've given you an opportunity to speak, and if any commissioner wishes to ask you a question, we will ask you. Any questions for the parties from the commissioners or comments? Commissioner Studley.
I have a comment about why this seems challenging to me, and it relates to the last part of the definition of official misconduct, which we haven't yet parsed, and I expect will be a very challenging interpretation of what the voters intended. But the language about conduct that falls below the standard of decency, good faith, and right action, impliedly required of all public officers, is important to me in relation to some of these statements and some of the information, because while at this point I am with you on not thinking about the consequences of the action, I'm wondering whether there's something embedded in the conduct requirement about good faith and right action, about the capacity to carry out the job going forward, that we might want to have the basis for discussing later when we review this interpretation. So I'm hesitant to be too narrow in bringing in the facts that we may need later when we talk about how to interpret the conduct that falls below the standard of good faith and right action required of all public officers, a few words deleted.
So, and in that vein, and my attempt to be sensitive to that concern, I don't think 1 through 18 would help us in that regard. I think that to me, those paragraphs are about what it means to be chief of APD, and I don't think that's relevant to our inquiry. So, I think what we're talking about are paragraphs 25 through 28.
Right.
And
would 25 be in under your initial
No, 25 would
recommendation?
not. And my reasoning on 25 was that
all sorts of things.
Yeah, I mean, it seemed fairly conclusory and general. To me, much more prejudicial than probative. But it does address the issue that you and Mr. Rennie have identified. So I can understand the concern with respect to those paragraphs. Those paragraphs, I apologize.
Could you just restate what you would keep?
I would keep, beginning with the second sentence of paragraph 26, through the remainder of that paragraph, and all of paragraph 27.
I'm fine with that. I'm fine with that.
I would be fine with that, too. I do think, I was struggling with paragraph 25. I do think it's speculative and conclusory. So I would be fine if we could keep in what you said, the portions you said for paragraphs 26 and 27, and the paragraphs that are not objected to by the sheriff.
Is there a motion with respect to the declaration of Wendy Still?
So moved.
Is there a second?
Second?
All in favor of sustaining the objection to paragraphs 1 through 18 and to the first sentence of paragraph 26 and paragraph 28? All in favor?
Aye.
Opposed? Hearing none, the motion passes. Paragraphs 1 through 18 are excluded. If the first sentence of paragraph 26 is excluded, paragraph 28 is excluded. Paragraphs 19 through 22 are admitted, as well as exhibits 36 through 41. And paragraph 26, beginning with the second sentence and continuing through the end of paragraph 27. Paragraph 25 was excluded. The next declaration is the declaration of Richard Danielle. Ms. Kaiser?
I would actually like to make an objection for the record, Commissioner. You have gone paragraph by paragraph through a declaration based on objections of which we had no notice without any opportunity for us to comment. I do have explanations for why, based on your objections, some of that testimony was admissible, and I would have appreciated, for my client's sake, the ability to explain those to the Commission. So I object to the procedure of entertaining objections that were not raised by the Sheriff without giving the Mayor an opportunity to speak. Thank you.
So you have nothing with respect to Mr. Danielle?
No, I'm making a record. I'm making a record of my objection.
To Mr. Danielle?
No, I'm making a record of my objection to the Commission's procedure on the last declaration.
Okay, well, I was asking for your response to the objections to Richard Danielle.
I'll cede to my colleague, Mr. Keith, for that.
Okay, in response, before Mr. Keith gets up then, in response to your point, Ms. Kaiser, we are trying to provide both parties the opportunity to give their views on the evidence, and I think we did that. The objection that was sustained was the one that was put in on the papers, which was it's irrelevant. I think you had adequate opportunity to respond to that. We provided you with that opportunity, and I'm sorry that you feel that way, and we will certainly endeavor to provide both parties the opportunity they feel they need to object. But we also are trying to conduct these proceedings in a fair and efficient manner. Mr. Keith?
Thank you, Commissioners. So the objection to the declaration of Inspector Daniele, there was an objection to paragraphs 27. Well, I'll take the objections to the exhibit separately from the objections to the testimony. There were objections to paragraphs 27 through 32 of that testimony. That testimony relates, I should say, 27 through 31 relates to the handing over of the sheriff's firearms, and it begins with the service of an emergency protective order on the sheriff at the time of his arrest, an agreement made by the sheriff and his attorney with the two police inspectors to turn over the sheriff's weapons, and also statements by the sheriff with regard to the number of weapons he had, which ended up not being true. The objection that's made is relevant, and the reason that this information is relevant is that it is relevant to whether Sheriff Mirkarimi met the standard of conduct expected by a public official, and specifically by a law enforcement officer. A law enforcement officer is expected to be honest in all aspects related to an investigation. The evidence that we've submitted regarding the code of conduct in the Sheriff Department, the law enforcement code of conduct, as well as the declaration of Chief Lansdowne, indicates that not being accurate, or even worse, not being truthful about the number and location of one's weapons in response to questions from inspectors falls below the standard of conduct expected of a chief law enforcement officer. Moreover, the subsequent conduct by Sheriff Mirkarimi of not actually turning over the weapon to the San Francisco Police Department is relevant because he chose to retain those weapons within his own department, thereby keeping the weapons within the control of his department, which is a violation of the emergency protective order, and also puts his subordinates in the position of unbeknownst to them, recovering these weapons, even though that breaches an agreement that the sheriff made with the police that he would give them the weapons. Now, the way that this incident was ultimately resolved was that the court issued an order to the sheriff's department when it found out what happened. The testimony, or excuse me, the transcript of that court proceeding involving, that was before Judge Breal of the Superior Court, when she found that the weapons were in the possession of the sheriff's department, she said, no, they need to go to the police department. The issue of the number of weapons was not brought up to Judge Breal, but the issue of the sheriff's department having the weapons was brought up to her. She transferred the possession of those weapons, or she issued an order to transfer possession of those weapons to the police department. She recognized that this was not the correct thing to do, in addition to Chief Lansdowne recognizing it. So for all of these reasons, we view this information as relevant to the commission. And I note that one of the exhibits that are objected to is Exhibit 7, and that's the order issued by the court to turn over to the sheriff's department to turn over the weapons to the police department. So, and then Exhibit 4 is, of course, the video, and I think we should probably take that separately because it's a different kind of objection.
I think that I agree with your proposal with respect to the video, Mr. Keith. Any questions for Mr. Keith with respect to Mr. Danielle's, Commissioner Liu?
Mr. Keith, so this issue with the weapons and turning over the firearms, or not being truthful about turning over the firearms, what count does that go to? What is it that we have to resolve about that, and which count is that relevant to in terms of your amended charge?
It is both a duty of the office it is both a duty of a chief law enforcement officer and every law enforcement officer to cooperate and be truthful in an investigation. That is not spelled out as a separate charge. For us, that's part of the analysis whether the conduct here fell below the standard of decency that was expected. So it would be to the fifth and sixth charges, which are standard of decency charges. One is to being a member of the Board of Supervisors. The other is to being a sheriff. We think, in our opinion, whether one is a member of the Board of Supervisors or a sheriff, one should not lie to police officers about the location and number of one's weapons. But it's certainly more severe for a sheriff to have done so.
Okay, but just to be clear, there's no factual allegation in the amended charges relating to this, the turning over of the weapons.
There is.
There is.
Yes.
Can you put it in the paragraph?
It's in the factual narrative, and I can provide those to you. It is paragraph 26.
He's right. There it is.
And the act of dishonesty is not mentioned there. It was something that was not full, that our investigation had not fully uncovered at that time. That came subsequent. But the issue of him retaining the guns within the control of his own department is framed in the charges.
Thank you, Mr. Keith. Any other questions for Mr. Keith?
Oh, and I'm sorry, I should add, this is also, the one other reason this is relevant is it is the behavior that the sheriff engaged in this regard is relevant to Nancy Lemon's expert opinion regarding batterers and firearms. And the paragraphs where she discusses that is paragraphs 80.
I'm sorry to interrupt you, Mr. Keith. Is the sheriff's office in here, or the law enforcement? Can we bring law enforcement in here, please? Sir, if you could please help keep order within the hearing room, we'd appreciate your help. Thank you very much. Pardon the interruption, Mr. Keith.
Thank you. In addition, I was saying in addition to being relevant to Chief Lansdowne's opinion, which I discussed earlier, it is relevant to Nancy Lemon's opinion regarding batterers and firearms, and the relevance of that is discussed at paragraphs 82 through 84 of her declaration.
Any other questions for Mr. Keith? I'd invite Mr. Kopp or Mr. Wagner to respond with respect to Richard Danielle.
Thank you. I admire creative lawyering as much as the next guy. And I'm almost at a loss to know what to say about this, almost, but I actually probably can figure out something to say. I would note that the original written charges made no mention of any of this. So maybe, again, this is a case of file first and figure out what happened later. But I think that there is a real danger, without being too flippant, of permitting this thing to morph as we go along. We could wind up with a situation where by the time we're all done, we get yet another amendment, and now there are new facts and new issues that we need to deal with. In the end, I think that these paragraphs and this exhibit are irrelevant. They are of such little probative value that it's a waste of time to even be talking about it. So that's the reason for our objection. I'm happy to answer any questions that anyone has.
So setting aside the connection between the paragraph 26 and the Lemon Declaration, I mean, what about the argument that paragraph 26 does include allegations about the sheriff's alleged failure to transfer the firearms appropriately? Why isn't Mr. Danielle's testimony relevant to that?
I don't think that that's relevant to any of the charges here.
I mean, it's
I'm not sure that I can elaborate any further on that. I'd be willing to submit unless the Commissioner has further questions.
Any other questions for Mr. Kopp? Here's my view on this. I do not think that the alleged dishonest statements have been sufficiently alleged in the charges. I do think the charges do sufficiently allege the failure to appropriately transfer the firearms. That said, in light of what I thought this hearing was going to be focused on, I do think it's a close call as to whether we want to open the door to allegations about whether it should have gone to the police department or the sheriff's department. I mean, without the allegations relating to dishonesty, it frankly doesn't seem like, even if we were to find that this happened, that it would constitute official misconduct. So all that is to say that I am inclined to sustain the objection to paragraphs 27 through 32. I do want to reserve Exhibit 4, however. Questions for Mr. Keith or comments from the commissioners? Is there a motion to sustain the objection to paragraphs 23 through 32 in Exhibit 7?
So move.
What did I say? You said 23. 27, I believe. Thank you. 27 through 32 in Exhibit 7.
I'd so move.
Is there a second? Is there a second?
I'll second.
All in favor?
Aye.
Aye. Opposed? The motion passes 4-1. The paragraphs 27 through 32 are, the objection is sustained. They will be excluded. Exhibit 7 will be excluded. We still have the issue of Exhibit 4, the video. I would like to reserve discussion of the video until we get through some of the other declarations, if that's okay with the commission and the parties. Any objection to that? Okay, the next declaration is that of Callie Williams. Mr. Keith or Ms. Kaiser?
Chairman, if I might suggest, I think a lot of the admissibility arguments regarding the declaration of Callie Williams may turn on the arguments about admissibility of Ivory Williams' declaration. It might make, I think, the argument might be too abstract on Ms. Williams if we don't go first to Ms. Madison.
Okay, I guess here's my concern about Ms. Madison. That we received that declaration only recently, and I don't believe that the sheriff's team has had an opportunity to submit written objections. In discussions that scheduling discussions that I had with the parties, I did ask if the sheriff's counsel could be prepared to orally discuss their objections, if any, to Ms. Madison. Mr. Kopp or Mr. Wagner, are you prepared to do that? Okay, so why don't we...
I am.
Thank you, Mr. Kopp.
Thank you for using the microphone. Some of us are hearing impaired. Thank you.
Okay, before we get to, and I think it's a good suggestion, Mr. Keith, before we get to Ms. Madison and Ms. Williams, Mr. Kopp, I have a couple questions for you in light of the rulings on the other witnesses. Do I understand that you will not, well, obviously you will not have any need to cross-examine Paul Henderson?
Correct?
Do you have any need to cross-examine Wendy Still?
No.
Vicki Hennessy?
No.
Richard Danielle? I guess we're waiting on Exhibit 4. I mean, are you going to be challenging the chain of custody of the video or anything like that?
No.
Okay, so then no need to cross-examine Richard Danielle?
Correct.
Okay, that's helpful. Thank you.
I thought I put this in an email, but it's possible not everybody got it, but I did.
Oh, you did. I may have missed it.
It's fine.
Thank you. Okay. The other thing I wanted to ask was about Christine Flores. I think there was potentially a loophole in the order. We did not request objections to testimony. We requested objections to declarations. We did not receive any objections to Flores's transcript. Does that mean you're not objecting to the testimony that was submitted with respect to Ms. Flores?
No, it doesn't. We do object, and I apologize if I misunderstood anything the commission wanted. I think I made clear our objections at the last hearing, that we would continue to maintain an objection to her testimony as being not relevant to the issues here, given the fact that the sheriff has already submitted his declaration concerning his conduct. And the only reason that I could see that Ms. Flores would be, her testimony might be relevant would be if he denied that. So I have not submitted anything in writing yet. I don't recall the timing. My memory is Ms. Flores' information didn't come until after the bulk of the mayor's fact witnesses.
I think we got them with the fact witnesses, if I recall. But Mr. Keith, maybe you can elaborate. Thank you.
There was, I guess, the order only spoke to declarations, so it didn't occur to us to put that in. We did put it in with our objections, but it frankly didn't cross our mind because it wasn't a declaration. I certainly don't begrudge my opponent the opportunity to submit a written objection. I think it probably would make sense.
Okay. Do you have a response to Mr. Kopp's oral objection with respect to Ms. Flores?
Well, yes. I mean, it's. Again, I wasn't anticipating we raise this objection, but I think I can outline the issues, and if the commission would like further information, we're certainly happy to provide it. And this is an important issue. I think in domestic violence-related cases, Evidence Code 1101 and 1109 permit the admission of other acts of domestic violence. The legislature has recognized that battering conduct happens repeatedly by a batterer, and they've made a special determination that this type of evidence can be admitted to be considered about whether a domestic violence incident actually occurred. This evidence is in addition, this evidence is relevant to Nancy Lemon's declaration because of the similarity of the incidents between Ms. Flores and Ms. Lopez's incident as she described it. So those are the basic reasons why we believe that this is admissible.
What about the argument that the physical abuse is not being disputed in this case?
I think it is. I mean, I think when we hear from the sheriff, we will find out perhaps. When we do hear from the sheriff, we may find out more information than the sentence or two that's contained in the declaration. Certainly the accounts that Ms. Lopez gave, and this may be shading a bit into our arguments about the Madison Declaration in the video, signified an incident that looked a lot more severe than an arm grab that occurred at the end of an argument. And we think that this is certainly relevant to determining the issues in the case.
I think the commission might benefit. Did the commissioners have views or questions for Mr. Keith about Christine Flores?
Pardon me, I
didn't. Does the commission, any members of the commission, have views on Ms. Flores or questions for Mr. Keith?
Well, I have serious questions as to whether or not it's relevant and should be admitted, and I'm not convinced at this time that it is relevant to the issues that we have to decide, in spite of the fact that you say maybe in a trial of domestic violence and an allegation it might come in. I'm not sure, though, in view of the fact of what I understand will be the sheriff's testimony, that it doesn't, I don't think it does more, it's more prejudicial. And the testimony, as I understand it, was taken in camera because the judge felt it was something that should not be a public record, at least at that point. And I don't know, and maybe you can answer the question, was it ever released to the public?
It was. The hearing occurred over 2 days, and it was a 402 hearing, which is fairly standard when this type of evidence is sought to be admitted. The judge actually opened the hearing on the second day. He had initially had it closed. He opened it on the second day. And so the materials did become public. We've checked with Ms. Flores. She was comfortable with us submitting this, so there's no issue there. The judge didn't necessarily. I mean, the judge, I think, held an in-camera hearing for the benefit of Ms. Flores more than anyone else. It wasn't that the evidence was unreliable, but more just the fact that any sort of domestic violence incident has potential sensitivities. I think as to the point of the differing accounts here, I mean, this really raises an issue of legal interpretation. And the issue is this: for purposes of official misconduct, does it matter how serious a domestic violence incident is? I'm not prepared to say that it doesn't matter. I mean, perhaps the ultimate decision by the commission will be that the seriousness of an incident doesn't matter, but I think that we would really be cutting off, that potential issue far too early if we sort of say that all that matters is the fact that an incident occurred and that a conviction and sentence and probation came out of it. So I think that
So if I understand your view then, if the testimony that's elicited or if the evidence comes in that the physical conduct was beyond what was stated in Mr. Mirkarimi's declaration, that you think that makes the Flores testimony relevant per Rule 1109?
Well, I think that if it is relevant what happened in a domestic violence incident, then Christina Flores' declaration is relevant because it tells us whether this was, a one-time accident or whether it was a conscious use of power to cause an injury.
But if it's conceded that it wasn't an accident, then why, in other words, if the fact that you're seeking to establish is conceded, why do we need Flores to help bolster that fact?
Well, I think Christina Flores' testimony goes to not just to the existence of domestic abuse, but a pattern of domestic abuse and abuse of power within the relationship that comes with it. And so that makes her testimony relevant because it shows that this is occurring within a domestic violence, within basically a batterer mentality, because there is a batterer mentality, there is a batterer way of being in relationships, and that makes it more likely that this incident occurred and that the allegations regarding abuse of power, not just within the relationship, but abuse of political power, are more likely to be true. I mean, again, these are things that are in Nancy Lemon's declaration about the nature of domestic violence being an exercise of power as opposed to a loss of temper. So it would still be relevant to that power issue. But again, I want to return to the original point, which is if it matters at all how serious an underlying incident is, then we don't want to cut off that line of inquiry. And again, Flores' declaration goes to this.
Thank you, Mr. Heath. I'm inclined to agree with Mr. Rennie on this. That said, there were no written objections, and I know, Mr. Keith, you ably orally advocated, but if you'd like the opportunity to submit written objections, given that Ms. Flores is not coming in to testify, I think we could wait for written objections if the commission agrees and if the parties agreed. Any comments from the commissioners on that?
Written objections by whom? By the sheriff?
The sheriff would submit his written objections, and the mayor would be able to respond.
Fine.
Well, I think I do want to see what the briefing is, the written objections on the 1101 issue, but it also seems like until the sheriff testifies, we might not really know the extent and the parameters of the facts we're looking at. So I don't think I'd be comfortable just outright excluding this at the outset before we know what the scope of the facts or what the concessions are.
I agree with that. So if the parties, Mr. Kopp, if you feel you'd like to add to your oral objections in writing, that is fine. Mr. Keith, we'd ask for a response within 3 days of receiving the objections, or 3 business days.
My suggestion would be this, that we key it off of Sheriff Mirkarimi's testimony so that the parties have an opportunity to raise that issue.
I think that's a good idea. Okay. Ivory Madison. Mr. Kopp. It's a long declaration.
Very long.
I'm trying to think of the best way to actually go about doing this. My initial inclination was to go paragraph by paragraph consecutively and for you to identify any paragraphs or portions thereof that you object to. I welcome the views of my fellow commissioners on whether there's a more efficient way to handle that.
I don't know if there's a more efficient way, but I will have to say, and I'm addressing this to the city attorney's office, that I was disappointed by the contents of Ivory Madison's declaration, that I think a first-year lawyer would recognize that much of it is inadmissible and should not be presented to us. And so that rather than going through it paragraph by paragraph, which I think will just re-emphasize the prejudicial nature of much of the things that are contained in it, is I would be disposed to say we won't admit it at all, and you can bring her in as a live witness to testify to those portions which legitimately can be brought before us, rather than the kinds of statements that are being made that go back, some of them, and are clearly hearsay, clearly appear to have solely the purpose of sort of poisoning the well in this hearing. And I don't think that's what your responsibility is. Your responsibility is to present the case fairly with the facts that relate to the charge, not to things that may go totally extraneous, but obviously being a public document, the newspapers pick it up, and it gets bandied about with no opportunity to deal with it. So that my proposal may be extreme, but my proposal would be that we reject the declaration and to allow you to bring Ms. Madison in, and you can question her, and we would have an opportunity to, if objections are raised, to rule on that as to relevancy and as to admissibility.
Commissioner, may I respond?
Yes, Mr. Keith.
I was going to second that.
Mr. Keith, please.
Commissioner Rennie, I fully understand the criticism. We are in a situation where we have an independent witness who's represented by counsel, and we don't have control over what the witness submits. And the way that I would, had I been preparing this declaration for my client, I may have proceeded differently. And I may not have included everything that Ms. Madison included. She is an independent witness, and because of the way that we're proceeding by declaration, we don't have the kind of, I mean, I think for the reasons that the alternative procedure you brought up kind of raises this point, is that because we're proceeding by declaration, we don't have the kind of essentially decision by the presenting lawyer when somebody's represented by counsel about what questions to ask and the order in which to take things. So I think the criticism is well taken, and we certainly didn't intend to put matters before the commission that that are not relevant. She's not our client. We didn't have control of how she drafted. With regard to the procedure, I may very well not contest some of the objections that are being raised. I have to wait to hear them to make that decision, but we may agree that some of this is not admissible. And so I think it's still useful to go through the declaration and hear the objections, because it is going to make the procedure of taking testimony shorter. So that would be my suggestion. But I understand and appreciate the criticism.
Thank you, Mr. Keefe. Did you have any
My
follow-up, Mr. Rennie?
concern, when you say that you didn't have control over the witness and she had her own attorney, but you were the one who submitted the declaration. So you had to have looked at it and could have said to her attorney, these paragraphs are not relevant, or they're prejudicial and they don't relate to the issues. But I accept the difficulty you have under those circumstances. But again, the problem I have with going over paragraph by paragraph is that in order to do that, we simply have to repeat the same things that are being said and out into the mass media. The mass media can look at it now. And in fact, when this was filed, the next day, the Chronicle had portions of what was in their story. Now, fortunately, they didn't go into all the details, but that's the very thing that, and when I saw that, I thought to myself, maybe this idea of going by declarations was not necessarily the most protective of the interests of everybody, because if you had asked, or if the witness were alive and started to ask a question about something, an objection could be made, and it never gets into the record because you never get to answer it. Okay?
That's correct.
And so so I guess I would be more inclined to have Mr. Kopp prepare a written objection to the paragraphs by paragraphs, because there are some paragraphs that are clearly germane and probably admissible, but go by it paragraph by paragraph, and then we can rule on it, but without going through it orally tonight, which is what we would have to do without a written statement.
Other views from the commissioners? Mr. Rennie, I can certainly appreciate your concern. My concern with written objections with respect to Ms. Madison is that Mr. Kopp is prepared to tell us what the objections are. I think there are legal issues with respect to what relevant testimony can come in from this declaration that I think are going to be informative about a number of issues. So in light of that, I would still propose that we go through it. I would ask that if there is a stipulation on a paragraph not that shouldn't be admitted, that it just be stated and that we don't have a recitation of what the paragraph is about. If this becomes overly prejudicial, then I think we can reconsider. But I think we can get to the parts of this declaration that are actually going to be at issue, hopefully, quickly. Is that acceptable to the Commission?
Yes.
Mr. Kopp.
Can I just voice a concern that I had, because I had the same concern that Mr. Rennie just voiced, which is I did not want to have to go through and have the sentences read out as to what they all are, and my concern is that when Mr. Keith responds to my objections, he's probably, I would think he would want to explain to you why they are relevant, and that would necessitate that recitation of these facts. So I'm not so sure this is going to work. I'm willing to give it a try. I'm going to make my objections in the most legal and general terms without addressing the specifics.
Okay, let's try it.
Okay. So we don't object to paragraphs 1, 2, 3, 4, and that's as far as I got. We object to paragraph 5 on relevance grounds.
Okay, any other bases?
Well, the first sentence is probably more prejudicial than probative, so under 352. I mean, when I say relevance grounds, I don't know if you want me to spell out the parts specifically that I think are more prejudicial than probative. I'm happy to do that.
I can actually short circuit this. The second half well, let me say specifically paragraph 5.
Yes.
Oh, I'm sorry. Does this one work? No, we'll have to share.
Okay.
You think we could fix that?
Paragraph 5, lines 9 through 10. I think we would agree that the part of the sentence beginning with including is not relevant.
Is that sufficient to address the objection to the first sentence of paragraph 5?
Yes.
Okay. And then, Mr. Kopp, do you have any further objection to paragraph 5?
Relevance as to the rest of it.
The rest of it. Mr. Keefe?
Oh, we would say it would defeat the claim of bias that's being made against Ms. Madison and Mr. Mertens, the fact that they supported the sheriff in his campaign, and that bias somehow motivated their reporting of this incident.
I tend to agree with that, that it is admissible to combat bias. Any objection from the commission? Okay. Paragraph 6.
Yes, we object on relevance grounds as to its entirety. In addition, we don't believe that there is foundation for the last sentence, and we believe that the last, or excuse me, the third sentence, we don't think there's foundation. We'll strike that. We also think that the last 3, 4, 5.
Mr. Kopp, can you just say the line number?
Is that easier?
Yes.
Okay. So we think that lines 17 through 23 are speculative. And again, more prejudicial than probative.
Mr. Keefe?
We think that this is not offered. Well, this is offered to show the relationship between Ms. Lopez and Ms. Madison that is really relevant to why Ms. Madison chose to make the report and the kind of advice that she was giving to Ms. Lopez later. And we think, I mean, for that purpose, it is relevant. I mean, I think there's a lot of details in here that are probably not necessary, but it's offered simply to show the course of the relationship and explain, again, the motivation for reporting later on.
I would sustain the objection to the entirety of paragraph 6. Any dissenting views from the commission?
No.
I'm sorry, if I could just ask the commission to keep the first sentence just simply that this was something that they discussed at this time without reference to the content or Ms. Madison's reaction to it. Again, that just goes to the relationship.
Any objection to that, Mr. Kopp?
Oh, I'm sorry.
Just the first sentence.
The first sentence is okay with us.
Okay, so 6 will be stricken except for the first sentence.
Commissioner, could I just ask clarification on paragraph 5? The portion that was stricken is the clause that begins with the word including and ends with the word salary, and the balance was admitted?
Yes.
Thank you.
Thank you, Mr. Emblich.
If we do 7-3.
I'm just waiting. Are you
Oh,
waiting
yeah,
for me?
well, I'm sorry. I'm waiting for you, Mr. Cobb.
I thought everybody was just reading paragraph 7. So we object to this paragraph in its entirety on relevance grounds. Additionally, there's no foundation for most of these sentences. And finally, this information is much more prejudicial than probative of any issue.
Can you tell us the next paragraph you don't object to, just so that, just in case there are consecutive paragraphs, we can maybe deal with them?
If I can, may I just have a moment, please?
Yes.
I think I'm going to have to go all the way to paragraph 38 before I don't have an objection, and that's a ways down the road.
Okay.
There's going to be a standing hearsay objection to anything Ms. Madison says that Ms. Lopez told her at any point in time.
Okay.
And then there are going to be numerous other objections.
Let's take it paragraph by paragraph then. Paragraph 7, is there a, Mr. Keefe, do you object to the striking of paragraph 7?
Yes. I mean, I think I can talk about a few of these paragraphs together, paragraphs 7 through 9. These are paragraphs that describe what Ileana Lopez is telling Ms. Madison about her relationship. And this is foundational, or this is information that's relied on by Nancy Lemon in analyzing the state of the relationship that they have. It's well accepted that expert opinions regarding domestic violence situations and batterer relationships can and do rely on this kind of confidences given to friends and other people close to the victim, even if they are hearsay. I mean, we're not offering this for the truth of the matter. We're offering this to establish the nature of the relationship so that we can figure out what it is that's going on. And to some extent, to the extent that the paragraphs also discuss Ms. Lopez's response to these things that are going on in the marriage, they pertain to her state of mind and help explain her conduct later on. So that would be our point for 7 through 9.
Commissioner Sedley.
I wonder whether the right question is whether Ms. Lopez's testimony is the better source of any of that kind of information.
Go ahead, Mr. Keefe.
I don't doubt that her testimony would be helpful. But I think one reason that this kind of testimony is permitted in cases involving domestic violence, again, not for the truth of the matter, but for the nature of the relationship and the motivation of the victim, and to explain the actions of the victim, it's often because victims recant, which is, again, something that's covered in Ms. Lemon's declaration. So, I mean, we may or may not hear from Ms. Lopez. In the meantime, we have this, and it's recognized under the law that these kinds of statements can come in to support an expert opinion, even if they're not in for the truth.
Well,
Mr.
when you say you aren't introducing them for the truth or falsity of the statements that are being made and attributed to Ms. Lopez, if they're untrue, they're meaningless, right? So you are arguing that what Ms. Madison says Ms. Lopez told her was in fact a true statement of fact. Isn't that a classic hearsay?
It is, but it's a kind of except insofar as it explains Ms. Lopez's course of conduct and why she was doing what she was doing at a later time. Then it is permitted under an exception to the hearsay rule. But it's not. But even if it is hearsay, and for the truth of the matter as it is still permitted for an expert witness to rely on these types of confidences given to a friend about the nature of the relationship.
I would strike paragraphs 7, 8, and 9 in their entirety. I think they're more prejudicial than probative, and I don't think none of the statements here, I mean, there can be some foundation, and we've already discussed that there is some foundation that they have a relationship, but I don't think this is probative of what the allegations and charges that we're seeking to adjudicate. I welcome comments from the commissioners or questions for Mr. Keith. Okay, hearing no objection, and we can vote at the end, but I take it there's no objection to the sustaining of objections to 7, 8, and 9 among the commissioners.
Correct. No objection.
Okay, paragraph 10, I think that was where we had left off. I don't know if Mr. Keith, you want to address it, or Mr. Kopp, either way.
I mean, I think this is a little different from the prior paragraphs in terms of trying to assess Ms. Lopez's attitudes and state of mind, regardless of whether the paragraph 10 relates to various concerns she had about Theo and his welfare. Whether or not any of these incidents actually happened, she had that concern, and that concern is relevant to the actions that she later took. So in that sense, that is why this information is offered. It's not offered to show that all of these things actually occurred. It's offered to show her concern for Theo, which explains her actions around the time frame of the 31st through the 4th.
Okay. Any questions for Mr. Keith with respect to paragraph 10? Mr. Kopp?
Yes, thank you. Again, we object on hearsay and relevance grounds, also that, again, this information is more prejudicial than it is probative. And I would like to just address one comment made by Mr. Keith a moment ago, which is that their expert witness wants to rely on this stuff, assuming the truth of it. I mean, why would you rely on it if it wasn't true? Their expert, Ms. Lemon, can rely on whatever she wants. That doesn't mean it needs to come into evidence before the commission. So I'd like to make that comment.
My view is that the entirety of paragraph 10 should be stricken for the reasons stated by counsel, and I think it's similar in nature to paragraphs 7 through 9. Any dissenting view from the commissioners? Okay. Hearing none. Paragraph 11, I do think may have we may finally get to some potentially relevant evidence. Let me hear the objections to 11 and figure out what we need from this.
The objection here is primarily going to be hearsay. I would agree that there's more probative information in this paragraph than any of the previous ones we've objected to. Some of it contains information that is prejudicial, but our primary objection here is hearsay.
Mr. Keith, unless there are questions from the commissioners for Mr. Kopp.
Well, I think this is where we start to get into the issues that we submitted a brief on why this is subject to hearsay exceptions, most notably the excited utterance rule, but also exceptions to show the state of mind and to explain the conduct of what happened and how Ms. Lopez ended up making this video. So, again, I mean, I think the issue of the excited utterance, we have ample evidence from Ms. Lopez's description, from Ms. Madison's description of Ms. Lopez's demeanor, that she burst into tears, she was distraught, she burst into tears again, she was emotional, And that likewise, that emotional demeanor is likewise reflected on the video. It's evident to see it, and from Ms. Lopez's manner of speech on the video and her bursting into tears on the video. So we think that this, as well as some of the other paragraphs that we're likely to discuss, should come in under those hearsay exceptions. So for the reasons we briefed.
Questions for Mr. Keith with respect to paragraph 11? In light of the state court's decision with respect to the testimony of Ms. Madison and the case law cited therein about what an excited utterance can mean under California law, it does seem to me that statements made by Ms. Lopez on January 1st should come in. Now, I don't think, as we sit here today, we have to decide whether they come in for the truth. Whether they come in as admissible non-hearsay evidence. But I do think that statements made to Ms. Lopez, made by Ms. Lopez to Ms. Madison on January 1st should be considered by the Commission.
I'm sorry.
Mr. Kopp.
Yeah, I'd just like to respond briefly, and I'm cognizant of the rulings that were made by the Superior Court on this issue. I would say that that determination does not bind you. There's no collateral estoppel effect because there's no privity between the parties. And I would like to just point out that an excited utterance or spontaneous statement exception, typically it does not apply when the statement's made a day after whatever the incident was that caused the excitement. Their caution is urged when it is a statement made in anticipation of litigation, and some of this explicitly states that Ms. Lopez was considering divorce proceedings. And moreover, in this particular paragraph, there are numerous references to questions being asked by Ms. Madison of Ms. Lopez. So it's more in the nature of an interviewing process rather than a torrent of words that just came out of Ms. Lopez because she couldn't control herself. And that's really what the hearsay exception is aimed at. So I'd like to have this.
You know, Mr. Kopp, one thing that comes to mind as we discuss this issue, I think we asked if you would be prepared today to tell us whether Ms. Lopez is going to submit a declaration. Do you have that information?
I do. And what I can tell you is because I do not speak directly with Ms. Lopez, I talked to her lawyer. I am informed that she is willing to submit a declaration. I don't have a firm grasp on what the timing of that would be, but I hope that it would be within the next week or so. Part of it is because it's responsive to these declarations that were just filed over the weekend or Friday, and then I guess again on Sunday. No decision has been made as to whether or not she is willing to either appear for live testimony or cross-examination or appear remotely. That's all I can tell you at this point.
When will you know? Will you get an answer?
I expect it within a week. I'm going to know. I should be able to get a declaration, or I hope to be able to get one, and I should have an answer as to whether or not she's willing to submit to cross-examination. Again, this is one of those. This is a situation where she's not a witness under our control.
Who is representing her?
Her lawyer is Paula Canny.
Mr. Elmridge, I would recommend that we put this on our list of individuals we may want to subpoena to appear before us at the next session. I think hearing from Ms. Canny directly may help us figure out what evidence, if any, from Ms. Lopez may come in.
I don't think you'll need to subpoena Ms. Canny. I think she'll probably.
Okay. Well, we don't really have an easy mechanism of ensuring her compliance beyond that.
Okay.
Unless you're telling me that.
I'm pretty sure.
Can I hold you responsible for getting her here then?
Well, she doesn't really listen to me, but I can certainly request, I can relay the fact that you've requested that she be here, and unless there's some conflict in her schedule, I'm sure she'll come.
Okay. I think we should put her on the list for a subpoena, and we can discuss with the rest of the commission whether.
If you want,
do that.
if we do have a break in the proceedings this evening, I can try to make a phone call and give you an answer.
Okay. Mr. Keith, did you have anything in response?
Yes. I think, just briefly dwelling on the merits of when this exception applies and when it doesn't, the key issue is the mental state of the speaker. And the question isn't so much when did the incident, the question isn't so much how much time has elapsed between when the incident occurred and when the utterance is made. It's what was the mental state of the speaker, and the cases we cite to that effect. And, there are many instances in which statements that come, a day later, even 2 days later, still come in as excited utterances. And I think the issue is less whether it comes in for non-hearsay purposes or for the truth of the matter than the weight that it's given. And I think at this point we're not really arguing weight; we're just arguing admissibility. So I think if there's a ruling that it's an excited utterance, it comes in, and then the commission can weigh that against whatever other evidence there might be about what occurred.
I'm inclined to agree that it should come in. I think we've discussed previously that the weight we give to hearsay evidence would be less than the weight we give to non-hearsay evidence. Like I said before, I don't think we need to decide right now whether it's coming in as non-hearsay evidence. But I, in light of how up in the air the testimony of Ms. Lopez is, I would be hesitant at this point to exclude these conversations from evidence. Any objections from the commission?
No.
Mr. Kopp, you had mentioned that you had some 352 objections to paragraph 11. Is there any, so you've heard what our view is on the admissibility of the conversations. Is there anything very specific within here that you're objecting to on 352 grounds?
If I can just have a moment, I'll let you know. Well, yes, lines 22 to 23, the last clause of that sentence I find more prejudicial than probative.
Beginning on line 23?
Beginning on line 22 after often, comma.
Okay.
So that second clause, or I guess it's a third clause, I'm sorry.
I'm sorry.
Right here.
Page 5 and this.
Yes.
From the word "and" through the word "abusive"?
Yes, thank you, Mr. Emlich. And
Excuse me, I'm having a hard time finding that.
on page 5,
On page 5, line
22.
22. I'm sorry. Okay, so the objection goes from "and" till the end of the sentence.
Correct.
We don't. We won't waste your time. That's fine with us.
Okay.
Yes.
So the objection to 22 beginning with and ending at the end of that sentence on line 23 is sustained. That will be not admitted.
Yes, and then the very next sentence on line 24, the last part of that, beginning with the word "because," I don't believe there's foundation for that. That's speculation.
Mr. Keith?
Our response would be that this explains her mental state and motivation and why she's so emotional about this incident. So it is relevant for that purpose. That we're not offering it for whether the child actually understood what was being said, but rather for Ms. Lopez's belief that he did, and that being the reason for her concern.
I'm inclined to allow that fragment of the sentence. Any objection?
No.
Okay.
And then the last sentence on page 5, beginning on line 26 with the word "as," all the way to the end of the sentence. we think there's no foundation, and that's speculative and prejudicial.
Well, that purports to be a
Speculative, it's
quote,
How could that be speculative?
isn't it? That purports to be a quote.
That's what it looks like.
So when you say no foundation, but it's what she's saying, this is what Ileana said to her.
Right.
Whether it's true or not is another question. But it's not being offered for that purpose at all. It's just being offered saying this was what she said, the words she spoke to her.
Well, I was a little unclear as to the reason why it was being offered.
I would be inclined to overrule that objection. Any dissenting view from the commission? Okay. Paragraph 12.
Yes, again, we have the standing hearsay objection as to the paragraph in its entirety. As to sentence number 2, on line 2, beginning with the words "from her description," that's speculation.
Mr. Keith?
Ms. Madison is just stating her interpretation of what Ms. Madison said. I just think sometimes we can have a conversation and get an impression, and she's repeating the impression she had based on what was said. I mean, obviously she wasn't there, but she is certainly able to give her interpretation of what somebody else said and the gist of what was being conveyed. I mean, that's standard, conversation and communication.
I would be inclined to overrule that objection. Any dissenting view from the commission?
No.
Mr. Kopp?
Yes. Then on line 7 to line 8, the sentence beginning with "I" and finishing with the word "am," more prejudicial than probative, irrelevant.
Mr. Keith?
Well, I actually don't have a problem with striking the last clause of the sentence. Let me bring this over, the microphone. The part that says, "and I still am," I agree that that's not relevant. What I do believe is relevant here is that it explains why Ms. Madison took the actions that she did, the concern that she had, and that this prompted her to take the actions that she took.
I would be inclined to sustain the objection to the last part of line 7 through the sentence that ends with "am" on line 8. Any dissenting view from the commission? Okay.
Just to clarify, what was it? Was the ruling that the whole sentence goes, or just
The whole
last
sentence.
clause?
So it begins with "I" at the end of line 7 and ends with "am" in the middle of line 8.
And nothing additional on that
Okay.
paragraph.
Paragraph 13, Mr. Kopp?
Yes. Again, hearsay to the whole thing, but lines 18 through 20, the sentences that begin "I asked," and then the next sentence begins "she said." Relevance, no foundation, it's speculation, prejudicial.
Mr. Keith?
I think that I actually don't agree with most of the objections, but it's probably not relevant within the stream of what's being conveyed. So I think that we wouldn't oppose that.
Okay. So that is, the objection is sustained by stipulation as to the sentence that begins "I asked" on line 18 and ends with the word "career" on line 20. Do I have that correct?
Yes.
Thank you. Paragraph 14.
Yes, hearsay as to the whole thing, and then the very last line, which is on page 7, lines 2 to 3, the very last sentence in that, beginning with the word my, finishing with the word do. There's no foundation. I'm sorry. Is that going too fast?
Nope.
Oh, no foundation for that and speculation.
The sentence beginning my. Yeah. Okay.
Mr. Keith?
I think that this is actually relevant to show Ms. Lopez's state of mind and to explain her hesitancy to call the police in this course of the conversation. Again, we're trying to ascertain why and how this investigation started, so it's relevant for that purpose.
Are we talking about line 2 and 3 on page 7?
Yes.
Well, that's not Miss, as I understand it, Miss Madison speculating as to why she says it's my impression. How is her impression, how is that a factual evidence?
I think it's her interpretation of what Ms. Lopez was saying. I think there is an argument that she is just, that she may be sharing her gloss on that, and it's not clear from the declaration. So I think, in light of the fact we can't ask her for clarification at this point, I'm not quite sure how to proceed on that.
I'd be inclined to sustain the objection. Any dissenting view from the commission? Hearing none, paragraph 15.
Yes, again, hearsay as to the entire paragraph on lines 10 through 13, the entire sentence, beginning with she, ending with argument. That's irrelevant and more prejudicial than probative.
Line 10, beginning with she and ending with argument. Okay. Mr. Keith?
Just a moment.
Sure.
Thank you. So this is relevant for this reason. Sheriff Mirkarimi has claimed in his public statements that he's referred to the custody laws as being powerful, that he never called himself a very powerful man. The fact that this exchange happened and that Ms. Lopez was communicating that she had asked, that she had brought up with her husband how this was a problem in the past, that he had made the statement that he was a powerful man and could use it to get custody of Theo. The fact that he has brought that there has been a previous discussion of this issue and her understanding of what he said tends to defeat Sheriff Mirkarimi's claim that there was some kind of a misunderstanding that he was really referring to the custody laws. If there were, that misunderstanding would have been cured by this conversation. So the fact that she's saying we talked about that this prompted a conversation before and she still had the same impression that he was threatening to use his power to take away Theo shows that it's not, that it wasn't a statement that the sheriff made that the custody laws were powerful.
Questions for Mr. Keith? Comments from the commissioners? This paragraph to me starts to get to statements that occurred on January 1st, but we're reflecting, it's getting closer to hearsay, clear hearsay to me.
But we're not offering it for what he said in that conversation or what she said in that conversation. We're offering it for the fact that there was a conversation about these comments in the past. If there was a conversation about these comments in the past, then it's likely that any misunderstanding about what the sheriff meant would have been clarified at that point. So again, it's not about what was said in these past conversations. It's that a conversation happened that is relevant.
I welcome the views of my fellow commissioners on this objection.
I mean, I would agree that I think we're getting a little farther afield from the excited utterance exception that you've been relying on, Mr. Keith. Do you?
Right. Well, the excited utterance exception would be if this were going to be admitted for the truth of what was said in these other conversations that had happened in the past. If we wanted to admit it for that purpose, but we don't. We only want to admit it for the purpose of showing that this issue about what he meant, or when he said he was a very powerful man, or that the fact that he had said it had come up in the past. And that is a non-hearsay purpose, just to show that there was a conversation, because if there was a conversation, the reason that this is relevant, if there was a conversation, that would have cured any misunderstanding. I mean, the claim here is that there was an accident or a misunderstanding of what the sheriff said.
Right, but so I would understand that it's not for the truth if we were trying to evaluate whether or not he was a powerful man who could take Theo away, who could take the child away. But the statement in of itself, whether or not it was made, is what is relevant to our inquiry as to whether it relates to official misconduct. So I do think it's still a hearsay purpose.
But this is about prior discussions that were prompted by similar statements. And our argument is, well, if she'd misunderstood him, surely those prior discussions would have clarified it. So
I would be inclined to overrule the objection on paragraph 15. And I would caution both parties again that when it comes to hearsay, we're going to need non-hearsay evidence. That hearsay might be used to bolster, but if the evidence is only hearsay, I think the commission is going to weigh it less. Is there any objection to the overruling of the objection to paragraph 15?
No.
Objection.
16.
Actually, I'm sorry, I wasn't quite through.
Oh, I'm sorry. You have more objections to paragraph 16?
I wish I had less.
15.
15, sorry. Yeah.
The last sentence in paragraph 15, beginning on line 14 and concluding on line 16, starting with the word she, I believe that's speculation and there's no foundation. It looks to me like this is Ms. Madison giving her impression, again, as to the reason why Ms. Lopez brought this issue up during this conversation.
Mr. Keith?
I agree.
Okay. That is stricken. The sentence beginning with she on line 14 and ending with threat on line 16. Paragraph 16.
Yes. Let's see. It's the fourth sentence beginning on line 20, ending on line 21, beginning with I, ending with the word that. The meaning of this sentence isn't clear to me, so I suppose the proper objection is unintelligible. And maybe I'm just dense on this, but I can't tell what that sentence says or means.
Okay. Mr. Keith?
Well, the sentence, what I think it means is that she didn't ask and she didn't know why Ms. Lopez kept saying in 2011. And I think that's the meaning of the sentence. It could have been conveyed in fewer words, but I think, she's honestly reporting, I didn't ask about this, but she kept saying in 2011. And I think that, as cryptic as this is, the meaning is clear that she didn't know why she kept saying 2011. It wasn't clear.
I'd be inclined to strike the sentence that begins I on line 20 and ends with that on line 21. I think that's speculation. Any objection? Or any dissenting view from the commission? Mr. Kopp, anything else in paragraph 16?
Yes. The next sentence now sounds like another level of hearsay. That is what this person in Venezuela said to Ms. Lopez. And again, it's not relevant. And then the very next sentence, beginning on line 23, I don't believe there's any foundation. That looks like speculation, and it's not relevant.
This is offered to show Ms. Lopez's state of mind and, perhaps, indicate what spurred her to action here. We're certainly not offering it for the truth of the conversation she had with somebody in Venezuela. It's to explain why Ms. Lopez was feeling the way she was feeling and the fact that she was feeling the way she was feeling. I think that a person can certainly interpret a look that they're given, a look of, well, that didn't work out so well. And I think that, again, explains Ms. Lopez's state of mind and explains why she chose to do what she did, which is to confide in a friend and make a video.
I would be inclined to sustain the objection to the sentence beginning she and ending with advice on line 21 and ending on line 24.
2 sentences.
I'm sorry. Thank you. The 2 sentences. Is there a dissenting view among the commissioners? Okay. Paragraph 17.
Yes, this entire paragraph is irrelevant, and I don't know how it could be more prejudicial than probative. I mean, the probative value here, in my opinion, is nil. The prejudicial value is extreme.
Mr. Keith?
One moment. So this is again explaining why Ms. Lopez felt that she had to make the video. I mean, we're not offering this for the truth of the matter. It explains her motivation for making the video, her concern in making the video, and her state of mind with regard to making the video and why she chose to make it. So again, I mean, we're not offering this for the truth of what's said. Again, it's to show why somebody did what they did, which is a proper non-hearsay purpose.
I would sustain the objection to paragraph 17 in its entirety. I think it's irrelevant, and I think it, to me, constitutes 352. Is there a dissenting view among the commissioners?
I agree.
Paragraph 18.
If you just pull it out.
Oh, okay.
The first sentence on paragraph 18, the second clause, comma, but as she knew, comma, there's no foundation for that, and it's speculation. I don't have any objection to the remainder of the sentence. Just my second objection is kind of along those lines, that the very next sentence on line 12 to line 13, beginning with the word since and ending with attorney. No, it's speculation. There's no foundation. Do you want to take that up first, and then I can continue, or should I just lay them all out?
Mr. Keith, any objection to those two?
I mean, yes, I think that Ms. Madison certainly has foundation to discuss what a friend knows about her because she has a relationship with that friend and has given her friend that information in the course of their relationship. And certainly a person is capable of saying that it's somebody who they've known for a long time, oh, they know that I'm not, that I am this or that I'm not this. I mean, it just comes with knowing somebody. So this is actually something that's within Ms. Madison's personal knowledge.
I'm not, that very well may be true, but I don't see anything in here that establishes that foundation. Had she said, I had told her, we had discussed it, but there's no foundation for why she knew. If you can point me to somewhere else where there is that foundation.
Okay, let me check for a moment. There is some foundation for that. I mean, in addition to the fact that the earlier paragraphs establish the existence of their relationship, on page 21, lines 6 through 8, there's references to sort of past details of what she had told her friend.
Okay. I would sustain the objections, the two objections. I think if those statements on page 21 come in, if there are, we could find those come in separately if we get to them. But I would sustain the objections and strike the phrase "but" ending with attorney on line 12, since beginning on 12 and ending on with attorney on 13. Any dissenting view from the commissioners?
Point of clarification. I thought the first objection was to the clause, but as she knew, as opposed to.
That actually would be, yes, we got, my mistake. That Ms. Madison is probably qualified to say that she was a practicing attorney.
I think so, yeah.
That she was never a practicing attorney. Okay.
As she knew is probably what should be taken out.
Thank you for the clarification. Mr. Emledge, on the second one, was that, did I get that right? Okay, let's get through paragraph 18, and then I think I'm going to have to propose a different mechanism for resolving these objections. Any further objections to 18?
Yes. I don't, irrelevant as to the rest of it, and moreover, I think this buttresses the point that I made earlier about the fact that none of this was a spontaneous statement because it was made in anticipation of litigation, specifically child custody and or divorce. But in any event, the rest of the paragraph is not relevant.
Mr. Keith?
Yeah, I agree. At this point, it may not be relevant.
Okay. So can you give me the line numbers again, Mr. Kopp? I didn't mark it when you first said it.
It would be line 13 to the end of that paragraph, which is on line 22.
So beginning with I on line 13.
And ending with okay.
Ending with okay on line 22.
Yes.
Okay, that objection is sustained. Okay, I mean,
I'm sorry. I would like to keep the last sentence just as it says. It's the course of the communication. I'm sorry. I think I spoke quicker than I should have. I apologize.
No problem. Okay, you're talking about the sentence that
I
begins.
asked her to let me know. I would keep that, and it just describes the course of what happened next in the conversation.
Any objection to that, Mr. Kopp?
Yes, I don't think it's relevant.
I'd be inclined to overrule that objection. Any dissenting view from the commission? Okay, we'll literally be here all night if we do this, and we have other declarations. I welcome views from the parties on how to handle this, and from my fellow commissioners.
I mean, I would propose that we do written objections and back and forth, and there may be very well be many that we agree on and don't contest, and that could speed things along. And plus, we won't have to do this on our feet, so we'll be able to go much more quickly.
Mr. Kopp, what do you think of that?
We're willing to do that. Our objections would probably be similar to what we've done already, and which is to state the legal objection and not really expand upon that. If you all are going to want us to speak further on it, I'm not sure that it actually will speed things up, but we can certainly try it.
Commissioners, views on handling this? Commissioner Hand?
I would just go back to what Commissioner Rennie originally proposed, and perhaps we could apply that to the second half of this declaration that we haven't gone through yet.
I think we should discuss that proposal. And I think relevant to that discussion, Mr. Kopp, will be whether you intend to cross-examine Ms. Madison based on what you've learned so far today with respect to the objections.
Well, my intent was that if the portions of the declaration that I thought should be excluded were excluded, that I did not intend to require her to appear for cross.
Okay. There are a number of areas where we sustained your objections, but with respect to the statements that were made to Ms. Madison by Ms. Lopez, we have overruled a number of those. But based on what you've heard now, if we sustained every other objection you had, you would not want to cross-examine Ms. Madison? Is that what you're saying?
Yes.
Okay.
I really don't know.
The proposal to simply permit Ms. Madison to testify and handle objections consistent with the Commission's views on her declaration, I would welcome the thoughts of my fellow commissioners on that. I think we know Mr. Rennie's and Commissioner Hand's view.
I would be fine with that. Yeah, that would be a fine way to proceed. And that would be a fine way to proceed, I think.
If Mr. Kopp, in fact, doesn't want to cross-examine Ms. Madison at this point, given what is in and what's out, we may not need to cross-examine. We may not need her to come in at all. So
that's kind of what I was thinking, Mr. Keith.
I'd be willing to take a good run at trying to do this on the papers, and hopefully, if we come back, we can go through the rest a lot more quickly.
Mr. Embledge?
I should relate to the commissioners that about a half an hour before tonight's hearing, I received a call from an attorney who identified himself as Ms. Madison's attorney. And for what it's worth to the commission, he expressed a concern by Ms. Madison about her continued public involvement in this proceeding and wanting to minimize that.
Okay.
And wanting to minimize that.
Okay, here are my competing concerns with this issue. I am cognizant that objections to the rest of this declaration may be so general that they may not really help us actually decide the issues. That said, I also don't want to inconvenience a witness. Finally, I'm reluctant to push off testimony, if we need it, from Ms. Madison further than the days we have allocated in June, and it seems to me that written objections would virtually necessitate that, because although maybe not, now that I'm thinking about this out loud, perhaps we could subpoena Ms. Madison to appear. We'll take the written objections. If they're helpful and we can resolve the issues with the declaration, Ms. Madison could appear. If Mr. Kopp doesn't want to cross her, we would excuse her. If we determine that the written objections are not helpful and that it would be more efficient to simply proceed with direct, we'd ask Mr. Keith that you be prepared to direct examine her. And then Mr. Kopp could decide after that if he wanted to conduct cross-examination.
Yeah, I mean, that's a possibility. As I reported in when we had a conference call regarding scheduling, my understanding from Ms. Madison's counsel is that he is unavailable through the 30th and very much wants to have the opportunity to prepare his client to testify if she is going to testify. And there may be other witness availability issues with the witness, Ms. Haynes, as well. So it may or may not be possible to finish by the 29th as fast as we want to go. But I know that taking a witness out of the equation gets us there faster. And so I would like to take a good run at trading objections and then meeting and conferring and really just trying to bring back to the commission those objections that maybe in bundles so that we can say this is all this type of testimony so we can get some quick rulings on the 28th.
Okay, here's what I propose. I propose that you do submit objections, Mr. Kopp. Mr. Keith, that you respond to them. Mr. Kopp, when can you submit objections to Madison and Mertens?
Well, to be safe, I would say not before Monday. I can try to get him in before then. It's Tuesday.
How about Friday?
I don't want to promise something that I can't deliver. If I can, I am happy to get those objections to the parties. I'd much prefer Monday, even if it was Monday early, so that I could have the weekend.
And are you comfortable then with if Mr. Mertens or Ms. Madison testify that it occur in July? I mean, you've been pushing for the schedule, so I just want to be clear that you're fine with testimony occurring later.
I think we're probably going to have to agree to that, unfortunately. And it does turn out that according to Ms. Peralta Haynes' attorney, she can't be available before July 9th. And I don't know if that's because she just had a baby or there are scheduling reasons. I don't have that information. So unfortunately, it sounds like there's going to be one date in July where there may be witness testimony.
Okay. That being the case, I have no objection to Monday, the 9th,
That's the 25th.
25th, thank you. Mr. Keith, when can you respond?
Well, I'm trying to build in time for us to meet and confer and bundle the objections so that we can just bring, hopefully, 5 or 6 to the commission to rule on instead of 20.
We would greatly appreciate that.
It'll be hard if I don't get them till the 25th, but I understand we all have other cases. So if I get the objections by the 25th, I could probably respond to them by the 20th. If the commission is going to decide these on the 28th, I think I need to get them on the 22nd, because then I would respond on the 25th, then we meet and confer, and then we'd have something to present to the commission maybe on the 27th, so that, basically say, here's the package of objections. So I think we need to move the schedule back a bit.
What if you got them at 9 a.m. on the 25th? Could you get them to us by close of business on the 27th?
Oh, you mean sort of an objection response?
Yeah, so we want your response to the objections and hopefully the narrowing that you've suggested.
Yeah, that would work.
Okay. Mr. Rennie?
I want to ask a question, Mr. Kopp. Why isn't it that you can't sit down tomorrow with the declaration in front of you, cross out all the lines that you don't want in? I mean, I've practiced law a lot longer than you, and my sense would be that you could do that in the space of an hour. I really believe you could do it in the space of an hour if you crossed out everything that you thought should not be in, give that to Mr. Keith, and Mr. Keith can either say he agrees or he disagrees, and I don't see any reason why it takes weeks to do something on a piece of paper. You've got, we're page 9 now, you've got 13 pages left. And I appreciate that you've got other cases, but I'm sure that your client believes that his case is number one. And certainly I believe the mayor believes this case is number one, and he wants to get it done.
Well, look, I should start off by saying I appreciate your confidence in me. However, if I were to say, yes, I can have this done by close of business tomorrow or even early Thursday, and I'm unable to do that, I don't want to commit to a schedule that I really think I might not be able to meet. I'll tell you, can I commit to Friday? Would that make everyone happy?
That would make us happier.
It might make some, but it wouldn't make me happy.
Well, but it sounds to me like that. If I can get it to Mr. Keith by sometime on Friday, hopefully sooner rather than later, that would solve the timing problems, would it not?
That would help. And so, Mr. Keith, in light of that, when would you be able to get us your response?
If Mr. Kopp is available to meet and confer on Monday afternoon, we could try and get you the response on Tuesday night, Tuesday the 27th. I'm sorry, Tuesday the 26th.
That would be appreciated. Okay, so Mr. Copps will be in by 5 p.m. on the 22nd. Or do we have a midnight deadline in this case for things? Is that going to make a difference to you, Mr. Keith?
Oh, I won't be looking at it Friday night.
Yeah, okay, that's what I figured. Okay, so same midnight deadline applies, 22nd and 26th. And that's for both Madison and Mertens.
Yes, understood.
Yes.
Okay. Does that cover all of the, sorry, Mr. Embledge.
I'm not clear whether you would like me to prepare a subpoena for Ms. Madison and Ms. Mertens to appear next week in light of what you've just heard.
I understand that Miss Madison and Mr. Mertens are represented by the same party. Is that, but the same lawyer?
I've been working with the same lawyer for both of them.
Okay, and he is with a firm, correct?
Yes.
So, I mean, I think we can handle this one of two ways. I think the commission can subpoena these witnesses. I think, I appreciate the attorney's desire to be there, but if he has partners at the firm, I don't have qualms with requesting the appearance of the witnesses with the other attorney. That said, if we're going to have additional testimony in July, I don't want to unnecessarily inconvenience a witness. So I think we could handle this one of two ways. We could subpoena her for the 29th, rule on the objections on the 28th, and if it turns out that we don't need her on the 29th, we can release her. Or we can rule on the objections on the 28th and then make a decision as to whether to subpoena her for a different date in July. And I welcome the views of the parties on those two proposals.
Commissioner, we prefer the latter only out of courtesy to the independent witnesses, both these witnesses and Ms. Peralta Haynes and their counsel. We just think that if we're going to have a hearing in July anyway, we might as well wait till July to see if it's necessary.
Mr. Kopp?
Well, it might force some of these issues by subpoenaing these witnesses for the next hearing. I don't necessarily have a strong view, but I don't know how to interpret what Mr. Embledge said, but it certainly makes me wonder whether or not this witness, if subpoenaed, will appear. And the sooner we knew that, the better.
From my communications with Mr. Roberts, I don't have any indication that she doesn't plan to appear, but I'm just relating what I know.
I did not get any indication to that effect either.
Commissioners' views on whether we should subpoena Mr. Mertens and Ms. Madison on the 29th, or whether we should await resolution of the objections prior to doing so.
And the information we have is that the attorney for those two witnesses is not available until sometime in July?
He did not express that. No, I'm sorry. He did express that to me, that he is not available the last week in June and the first week in July.
Which I think that mirrors Ms. Haynes's unavailability as well, or her counsel.
That sort of determines our going into July, don't you think?
Yeah, probably. Okay. In light of that, I think we should withhold issuing a subpoena for Ms. Madison and Mr. Mertens as of now. But unless there are dissenting views, I don't feel particularly strongly about it. Okay. Does that address all of the objections to the mayor's fact witness list? No, I'm sorry. We didn't address Ms. Williams.
Right.
I think with Ms. Williams, because the issues are similar, it is a shorter declaration. We could go through it if the parties wanted to, or if you think it would be helpful to meet and confer so that you can reach whatever stipulations that you may be able to reach with Ms. Williams that result from your discussions with the other two witnesses. We might be happy to hear that too.
Well, I could offer that I'd be willing to prepare my objections and submit them at the same time as the other objections to the Mertens and Madison declarations.
I mean, you submitted objections to Williams already.
Thank you for reminding me. If they needed to be expanded upon, if we needed to meet and confer, I'd be willing to do that. Otherwise,
I mean, I do think it may be helpful to do what you were planning to do with your objections to Ivory Madison's declaration the same way with Callie Williams, rather than just general objections to mostly all the paragraphs.
So I'm sorry, Commissioner Liu, you're saying if I could detail the objections with a bit more specificity as to particular sentences within paragraphs?
Correct. As Commissioner Rennie has suggested, just strike out the sentences just like you would any other evidentiary objection.
I suspect there are going to be fewer issues with Ms. Williams' declaration than there were with Ms. Madison's declaration. I think it may actually, we may be able to get through it pretty quickly.
If we dealt with it tonight.
I would suggest going through it right now.
Okay, we can give that a shot. I think we need to take a quick break. The court reporter certainly needs a break. So let's take 10 minutes. We will then resume. We'll start with Ms. Williams and see how that goes,
Okay.
and then we will try to address the objections of the other party.
Yes.
Excuse me, we are now back in session. I'd ask the audience to please allow us to proceed. Thanks very much. During the break, I met with the parties to discuss some scheduling issues as per the authority that was granted to me by the full commission. We will address those towards the end of the proceeding, but we did have some discussions about scheduling, and just wanted to make that clear on the record. Before we took our break, we were going to address the objections to Callie Williams.
Commissioner, if I might interrupt to make sure that we don't forget something that we left off earlier. Exhibit 4 to Inspector Danielli's declaration is the video. We were deferring ruling on that. Now that we've discussed some of the similar issues about excited utterances, I just want to make sure we get a ruling on the record regarding the video.
I have the video on my list, and I do intend to get to it.
Okay, thank you.
Okay. Callie Williams, we received objections from the sheriff. Do you care to respond to those, Mr. Keith?
Yes. I mean, the objections are primarily hearsay. The argument being this is what Ms. Lopez is basically giving an account of what happened on the 31st, but now it's the 4th. And so we're not arguing that the excited utterance applies anymore on the 4th, that Ms. Lopez's demeanor on the 4th was not, it wasn't distraught, and it wasn't to the same extreme that it was before Ms. Madison. So we're not arguing that these are admissible for the truth of the matter. But we do think it is admissible for legitimate and limited purposes, and so I'd like to argue those.
Okay. What are those?
So as we outlined in our brief, this conversation with Ms. Williams happened around 1 p.m., and Ms. Lopez both related the incident and told Ms. Williams some of her intentions that she had coming out of the incident, that she was thinking about reporting it, about going to her doctor. So it's relevant to where Ms. Lopez's state of mind was on the 4th, what her plan was, because as we laid out in the brief, Ms. Lopez underwent a big change in her state of mind on the 4th, from being ready to report this incident in the morning to around noon, still wanting to report it, but being iffy about repeating it to law enforcement, and then later in the day, essentially recanting, trying to stop anybody from reporting it. And so our argument is that on the 4th, there were intervening communications with Ms. Haynes and the sheriff, which are relevant to our charges. And what's very relevant is how that may have changed Ms. Lopez's mind about what she was going to do about this incident that happened on the 31st.
So who's going to create that link for you? In other words, who's going to testify that? And I understand. I'm following your argument with respect to you want to set up what the state of mind was and what the activities were before. But who should I expect will testify that there was such coercion by the sheriff to Ms. Lopez?
Well, we do have phone records which show a series of telephone calls, including long telephone calls with Ms. Haynes on the 4th, beginning earlier in the day, then continuing to the afternoon. And we also have text messages between the sheriff and Ms. Haynes that day that would tend to show what role Ms. Haynes was taking that day. Essentially, our argument, and this is an offer of proof more or less, that she was intending to protect the sheriff based on what was coming out of this December 13th incident.
And you have conversations or documents suggesting that the sheriff had talked to Ms. Haynes about providing this pressure?
We expect to get something about this from the testimony of Ms. Haynes and the sheriff.
Okay.
At least about contacts regarding this incident, and also their relationship and Ms. Haynes' statement of her purpose on the 4th. So Callie Williams' statement is first offered to show Ms. Lopez's state of mind with regard to reporting this incident, less so what exactly happened on the 31st. The second reason why the statement to Ms. Williams is relevant for a non-hearsay purpose is that there are substantial similarities between the accounts that Ms. Lopez gives to Ms. Williams and gave to Ms. Madison back on the 1st. That tends to defeat the claim, and it tends to defeat a claim of fabrication on the part of either of these witnesses or a claim of inaccuracy on the part of either of these witnesses, and it essentially gives greater weight to their testimony in that they independently say that Ms. Lopez was relating to them the same basic facts about what happened. So it tends to corroborate the credibility of these witnesses. And the third reason why we think it's admissible is, well, we already have evidence that there was an incident on the 31st. We have other admissible evidence about what happened in that incident in the form of the statements to Ms. Madison on the 1st, and this is basically under the administrative hearsay exception. It's hearsay that's allowed to be considered. There's no fact that's exclusively based on it, but it can still be considered by the Commission in terms of adding greater weight to the evidence that is admissible. So, I mean, as to the hearsay objection, those are our major arguments.
Okay. Although this may not make me popular, I think we do need to go through this paragraph by paragraph, particularly with respect to 4 through 18. There was an objection lodged to paragraph 4. The objection was relevance. Mr. Keith, do you object? Do you? What is your view with respect to paragraph 4?
So paragraph 4, it's basically just reporting the past relationship. It's establishing the relationship and also the existence of loud arguments, which, again, is about what's going on in the background of this relationship that's leading to this DV incident on the 31st.
I think paragraph 4 is irrelevant. I welcome the views of my fellow commissioners. I don't see why we need to get into what the person could or could not hear prior to December 31st, 2011, particularly when the statement is that he never personally had seen Ross acting physically abusive towards Eliana. Any dissent from the commissioners? Okay. Paragraph 4, objection sustained, and the paragraph 4 shall be excluded. Paragraph 5, Mr. Kopp has objected to paragraph 5 through 18 on hearsay grounds. I've heard the objection based on hearsay. What do you have a view as to the need for paragraph 5?
Well, 5 doesn't seem, there's no hearsay problem. She's just saying I wasn't home during this incident, so I have nothing to say about it. I mean, to me, that's relevant. It's just saying what the witness knows about.
I'll withdraw my objection to that paragraph.
Okay. Paragraph 6, it was an objection based on hearsay. Mr. Kopp, could you address that objection specifically?
Well, properly, it only the hearsay objection is only as to the statements that she's relating that Eliana Lopez told her. So it would be starting on line 10, finishing on line 12, beginning with the word she and ending with the word then. And actually, the middle sentence there isn't her, so it's really not.
I'm sorry, I don't know what you mean by
This one.
So I'm sorry, starting with the word "she" on line
10.
10 and ending with "then" on line 12.
Yes. So those are the portions that we object to.
I would be inclined to overrule that objection. I think it's, again, cautioning that it's been conceded that it's hearsay. We could consider it to bolster other evidence, but we likely would not rely on it as the sole evidence to establish a fact. Is there a dissent from the Commission with respect to the objection to lines 10 through 12? Okay, that objection is overruled. Paragraph 7, specific objections, Mr. Kopp?
Yes, hearsay as to the entire paragraph. Also, withdrawn, just hearsay.
Mr. Keith?
As I stated before, this is offered as administrative hearsay and also to bolster the reliability of the other statement to the witness, not for the truth of the matter.
I would be inclined to overrule the objection with the same caveat with respect to how hearsay should be handled and the weight it would be given. Any dissent from the commissioners?
No.
Paragraph 8.
I'm sorry, Chairperson Herr, I'm not sure if you want me to, because I have already lodged these objections, and I could probably tell you that, if you'll just give me a moment, I could tell you that whether or not there are any additional objections besides hearsay as to the remainder of these paragraphs through 18.
Okay. Sure. I'll give you a moment to do that.
I'm sorry, I do have some additional objections, so.
Okay, let's talk about paragraph 8. Your objection is hearsay. Mr. Keith, anything beyond the arguments you've made with respect to how to handle hearsay?
Not for paragraph 8, no. There are some additional ones for 9 and 10.
I'd be inclined to overrule the objection to paragraph 8, same caveat with respect to hearsay. Any dissenting view from the Commission?
No.
Paragraph 9. Mr. Kopp, maybe I'll first give you the opportunity if there are other objections besides hearsay, and then Mr. Keith can address.
Thank you, and I apologize that they were not all put down in writing. But in paragraph 9, beginning on line 5, starting with Eliana, through the end of that paragraph on line 11, irrelevant. Doesn't deal with the December 31st incident.
That's in addition to your hearsay argument.
Yes, sir.
Mr. Keith?
Okay, well, this is a new objection, but I'm happy to explain why it's relevant. well, first of all, okay, I'll deal with the relevance issue first. So this is basically describing Ms. Lopez's state of mind and where she was on the 4th, and where Ms. Lopez was on the 4th in terms of her intentions was influenced by what had gone on in the relationship before. This kind of information tends to show that that she had a reason for having the feelings that she said she was having at the time to Ms. Williams, and that's the second reason why this is, in addition to being administrative hearsay, and that it's more evidence of stuff that's already in, is that it shows that she was thinking about divorce at the time. So that this is her state of mind. It's that she's thinking about divorce and leaving her husband at this time, as opposed to essentially retreating later from the accusation of abuse and no longer thinking about divorce. So again, this shows where Ms. Lopez's state of mind was. And again, yeah, that's the issue.
Is it relevant to your allegations whether the physical conduct that allegedly occurred on December 31st was the first or second time it had occurred?
What is relevant about the earlier
Or is it
incident?
used? I'm sorry, I didn't.
What is relevant for us about the earlier incident is that it makes it more likely that the account that Ms. Lopez gave about that incident on the 31st is accurate. The account that she gave to Ms. Madison and then to Ms. Williams. It makes it more likely that it is true. So in that aspect, yes.
Mr. Kopp, do you have a response to that on that point?
Yes, on that point, it's pure character evidence, which should not be allowed. There was reference to Penal Code Section 1109, allowing this to be, prior conduct to be used in criminal prosecutions to prove conduct on a particular date by showing past instances. But that's not where we are. This is not a criminal proceeding, as I've been told. So I don't think, this should not be relevant to the inquiry, and I think all these references to anything that happened before December 31st are not admissible.
What authority do you have that 1109 only relates to criminal proceedings?
Commissioner, it actually says that.
Oh,
so
okay. Well,
I don't dispute that
it's
that's
not,
what 1109 says,
okay.
But we think it should nevertheless apply here, because in an administrative proceeding, the idea is to use reliable evidence, and if something is reliable enough to use in a criminal prosecution, it is certainly reliable enough to use in an administrative proceeding, particularly when the subject matter that we're dealing with is so similar. That is, what happened in this domestic violence incident of the 31st. So, though we fully concede that this is what the statute says, we think it's very appropriate to be using those rules in this proceeding regarding admissibility. Again, if it's reliable enough for a criminal conviction, it should be reliable enough for an administrative hearing, because that's what administrative hearings turn on, is reliable evidence.
But why then the limitation in the code that it relate to criminal proceedings?
You don't really have many civil proceedings about domestic violence. That would be my only response. And I don't know the legislature. I don't know what the legislature did. I just think that it's unusual to think about it coming up in a civil proceeding. But here we are.
Commissioners have views on this particular objection?
This is lines,
7 through...
Liliana, starting on 7 through line 11?
Correct.
I would be inclined to sustain the objection.
I also am inclined to sustain the objection. Are there dissenting views from the Commission?
I would just ask that the ruling be limited to the extent that it's offered for the truth of the matter as opposed to administrative hearsay purposes or to show state.
I guess I don't understand
Yeah,
the
I don't
distinction you're drawing there. If we exclude it, we exclude it.
Well, though, if there's other evidence in the record that tends to support this, then it can come in, though the fact that it's hearsay affects how much weight it's given.
Well, I think we're admitting evidence, even if it's hearsay, but telling you and the parties that it won't be, it may not receive any weight, even though it's been admitted. So I think our exclusion means that we're not going to consider it for any purpose. Now, if you bring it in in some other way, for example, well, I don't want to speculate as to how else you may try to bring it in, but
Well,
I would just leave it at that, unless there's some clarification you feel that you need.
Well, it is in the video. And it's also in the statement to Ivory Madison.
Okay, well, I haven't seen the video.
Yeah.
Whether it's in the statement to Ivory Madison, though, I think is different than whether it should be admitted from Callie Williams. So I'm going to sustain the objection unless there's dissent from the commission. Okay, paragraph, the rest of it, the hearsay objection is overruled. Same caution with respect to hearsay. Paragraph 10.
Beginning with she said. Is it paragraph 9, line 5, beginning with Ileana described?
I thought it was line 7, beginning with Aliana told me.
Oh, yes.
I had objected, I thought, to beginning on line 5 with Eliana described, so.
But then we move to the other incident.
Line 5, beginning with Aliana described. Things that have been.
That's what my objection was to, and
He started talking about 7, whatever he said.
I think the same rationale would apply there. Dissenting views from the commissioners?
I agree.
Okay, paragraph 9, lines 5 through 11 will be excluded. Paragraph 10.
yes, in addition to the hearsay, this entire paragraph appears to be speculation without an adequate foundation, and specifically line 21 to 22, that sentence that begins with Eliana and ends with Ross, I think that's irrelevant and it's more prejudicial than probative.
Okay, I want to hear, I understand your hearsay objection. I want to hear every objection you have to this paragraph that's not related to hearsay. Because I'm, just for efficiency purposes.
Sure, no foundation.
What parts?
Well, the way I understand the entire paragraph is this is the witness's interpretation of the things that were said to her by Eliana Lopez.
Well, some of them are statements that were made by Eliana. So what do you mean when you say the witness's impressions?
Well, when, for example, in line 13, when she says, as Eliana described it, that seems to me that this is her interpretation of what this comment means. And so that's why I think it's speculative. And
I would be inclined to overrule that objection. I think that's something that you could cross-examine a witness on if you wanted to. I think it's, again, it's hearsay, and we would give it the weight that the same weight we'd otherwise would, but I'd be inclined to permit that. Are there
As would I.
dissenting views?
Well, I have some difficulty with starting at the word "that" in line 17, which appears to be sort of her comment on what she had read or heard in the press about what Mr. Mirkarimi was saying. And I think that's probably improper, one witness commenting on another as to whether or not they think their statement is consistent.
Mr. Rennie, I apologize for my lack of clarity. I was referring to the objection to line 13 through the end of line 15. That was my fault. It's not clear.
Well, I also have, I mean, the next sentence on line 15, I think shows the uncertainty in her own mind as to what the comment was directed to. I have trouble with that paragraph, but.
Okay, so you would sustain the objection as to line 13 through 15.
Yes.
Other views of the commissioners? We certainly can take a vote.
Point of clarification, we're talking about line 13 beginning with "as Eliana" to the very end of line 15?
Correct.
Thank you.
No, you go ahead.
I would find that sentence, lines 13 to 15, acceptable, and would keep it in. Although the phrasing is a little different from other things. She is reporting on what she was told by Ms. Lopez, and as you said, I believe it could be successfully cross-examined.
And at least I am not making any statement as to how probative I think it is, but I do think it passes muster to be admitted.
I agree.
Is there a motion to, given the dissent, I think we should make a motion. Is there a motion to sustain the objection, to overrule the objection, thank you, with respect to lines 13 through 15 of paragraph 10? So moved. Is there a second?
Second.
All in favor?
Aye.
Opposed?
Aye.
The motion passes. Okay, Mr. Kopp, continuing with lines, anything between lines 16 and 23?
No, I'd just like to reiterate line 21, 22, irrelevant and more prejudicial than probative, that sentence beginning with Eliana and ending with Ross.
Mr. Keith, what does that go to?
It tends to show that Ms. Lopez accurately, or that Ms. Lopez certainly had the impression from what Sheriff Mirkarimi told her that he was trying to intimidate her with his personal power. So I don't think that it may be prejudicial, but it's not unduly prejudicial. It's not good for the sheriff's case, but that doesn't mean that it's inadmissible.
I would be inclined to overrule the objection. I think we're getting pretty close to the line here, but I think it could. I think it should be admitted for its limited purpose. Any dissenting view from the commissioners? Hearing none, the objection is overruled. Paragraph 11.
Yes, I had made the written objection that this entire paragraph was irrelevant, and on further review, I find it also to be prejudicial. are more prejudicial than probative, and would be excluded on those grounds.
Mr. Keith?
Well, evidence of other incidents is admissible to show intent or absence of mistake. Again, Sheriff Mirkarimi's public statements have been that when his very powerful comment was referring to child custody laws, not his political power. This is an instance in which Sheriff Mirkarimi, what was said in the paragraph speaks for itself, threatened to have DBI shut down the building because he was angry with Ms. Williams. That, again, tends to show the presence of intent or the absence of Ms. Lopez's allegedly mistaken interpretation.
I would be inclined to sustain the objection to paragraph 11. I think it's irrelevant. The stated purpose, I think, is it wouldn't go to providing us that additional assistance. Any dissent from the commissioners?
No, I agree that it's irrelevant. I don't think it helps us with what we're tasked to do here.
Hearing no objection, no dissent, the objection is sustained with respect to paragraph 11. Paragraph 12?
That's just a hearsay objection.
Okay. Given that we've heard from Mr. Keith on hearsay, I would be inclined to overrule that objection with the same caution with respect to hearsay. Is there a dissenting view with respect to paragraph 12? Hearing none, the objection is overruled. Paragraph 13?
Besides hearsay, it's irrelevant in its entirety.
Mr. Keith?
It's relating a fact about the nature of the relationship that Ms. Lopez had with the sheriff, which again goes to the nature of the relationship, which again goes to whether this is a domestic violence incident.
I'd be inclined to sustain the objection to paragraph 13. I think it's far afield from what we're trying to accomplish. Is there a dissent to that proposal? Hearing none, the objection to paragraph 13 is sustained. Paragraph 14.
Just hearsay on this.
In light of the arguments from Mr. Keith previously, I think the objection should be overruled with the same caution for hearsay. Any dissenting view?
If I might be heard, Commissioner, this does actually describe her observation of the bruise on that date, paragraph 14.
You overruled the objection.
Oh,
He's keeping it.
Yeah.
I'm sorry.
I think Mr. I think.
Oh, I'm sorry. I guess the caveat that I don't want it to be limited
Oh.
because it does describe a personal observation. Again, I don't know how these rulings are going to be reflected, sort of admitted light versus really admitted, but I think that we need to consider those statements really admitted.
Okay. Okay, so the objection to 14 is overruled. Again, if we admit something, it's admitted.
Yes.
What weight we give the evidence is going to may depend on whether it's hearsay or non-hearsay evidence and what it comes in for. So if it's sustained, then, yeah. Or if it's overruled, Mr. Keith, then you've won that objection. Okay.
I apologize. Mr. Keith had a more subtle question than I understood.
Okay, so 14 was overruled. 15.
Besides the hearsay objection, line 27, the portion of that sentence that is in quotes, beginning with the word see and ending with the word talk, there is no foundation, and that is speculation, not just on the part of Ms. Williams, but on Ms. Lopez.
Okay, I will say, and I'll give Mr. Keith an opportunity after I say this, that I think that's right, that it couldn't come in to prove that the sheriff was actually scared. I think, but it could come in to say that, to show that Ms. Lopez said that. Is that?
Yes, and in addition, it's also talking about the fact that, well, there the sheriff was at that time on that day, which is not hearsay.
I would be inclined to overrule that objection. Same caveats with respect to hearsay and the such. Any dissenting view?
Agree.
Okay, that objection is overruled. Mr. Kopp?
Yes, on paragraph 16, besides hearsay, this is irrelevant. And if I could just expand a little on that.
Okay.
You have heard several times this allegation that the sheriff persuaded either his wife or Ms. Peralta Haynes to try to dissuade witnesses from talking to the police. The problem is there isn't going to be any evidence before you now or at any point in the future that he ever did so. So whatever these communications were between Ms. Lopez and Ms. Williams, unless that could be linked to something Sheriff Mirkarimi did that was inappropriate, they're irrelevant.
Well, Mr. Kopp, you agree that there may not be direct evidence, but we certainly consider circumstantial evidence, can't we?
I believe that you can consider circumstantial evidence, but before you could draw, there would have to be some kind of a link before you could draw the conclusion that Sheriff Mirkarimi engaged in any of these allegations of witness dissuasion. And I don't believe that there's going to be any evidence upon which you could draw such a link.
Mr. Keith?
Well, I'm not sure where to begin. Let me clarify what the witness dissuasion theory is. It's not just that the sheriff, tried to get Ms. Madison to not go to the police and wasn't successful. It's that the sheriff did dissuade Ms. Lopez and was successful. I mean, that is a witness dissuasion claim in this case, and the other claim is that there were attempts to dissuade Ms. Madison which were unsuccessful. So I hope that clarifies the relevancy arguments. With regard to the hearsay objections, this is the fact that Ms. Lopez is sending emails at this time basically saying don't talk to anybody shows her state of mind and shows how different her position was earlier in the day when she was telling Ms. Williams that she was thinking of going to her doctor, and Ms. Williams said, wow, that's really brave. I'm glad you're telling people. So this shows where Ms. Lopez's state of mind is at that time with regard to reporting this incident or acting on it, which has changed. So that's why this is relevant.
My view is that this objection should be overruled. I think that it could be relevant depending on what other evidence is elicited about what, if any, conduct the sheriff engaged in with respect to these witness intimidation allegations. I mean, so I think at this point it would be difficult to rule that these should be out. Is there a dissent to that view? Hearing none, the objection to paragraph 16 is overruled.
And as to the remaining paragraphs, there are hearsay objections, and as to 18, 19, and 20, there are relevance objections.
Okay, so 18 was hearsay. Did you say relevance for 18 too? I just wanted to make sure I understood what you said.
17 was hearsay. I mean, there's hearsay as to all of them, but then relevance as to 18, 19, and 20.
My inclination with paragraph 17 is to overrule the objection. Is there a dissenting view from the commissioners? Hearing none, the objection is overruled. 18, a relevance objection was added. Mr. Keith, do you have?
I think for 18, 19, and 20, this really goes to the witnesses' I guess, lack of bias in the sense that what she did out of concern for Ms. Lopez, and even for a time didn't talk to the police and then finally did. I think it goes to the credibility of her statement. That's why it's relevant. It's not offered for the truth or anything. It's all about bias, or the lack thereof, which is always relevant.
I would be inclined to overrule the objections, the relevance objections to 18 through 20. Dissenting views from the commissioners?
As to paragraph 18, I would be inclined to delete everything starting on line 19 with I through line 24 as being irrelevant, and as to it showing that the witness doesn't have bias. I'm not sure there is at this point in the hearing any indication that Ms. Williams is being attacked for being biased. So it's until such time as her credibility is being attacked, I would be inclined to say it's irrelevant.
Mr. Rennie, I think you are correct with respect to when bias becomes relevant, but in my mind, given the way we have decided to handle evidence, and in the event we may not see a witness, I don't see the harm in having testimony regarding bias in a declaration, in an affirmative declaration, because to the extent there's further examination on it, we would have it, and I guess I don't see the harm in it. I welcome the views of you, Mr. Rennie, or other commissioners on that. And I guess further, to the extent that we're evaluating witnesses only on paper, I think it does help with credibility.
I'm willing to let it in. I'm willing to let it in as well.
Is there given that there are different viewpoints on this, is there a motion to overrule the objection to paragraph 18?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Opposed?
Opposed.
The objection is overruled. Any dissent from the commission with respect to overruling the objections 19 and 20?
Again, I would ask the question, what's the relevance of 19? What's contained in 19?
Mr. Keith?
It's just to show the relationship between the witnesses and also to show that they have not spoken with each other about the substance of what occurred.
That they have not spoken to each other?
That they have not spoken to each other about the substance of what Ms. Lopez told them.
How does it go to show that?
Because that's what it says.
Page 6, top of 6.
On page
line 1 and 2 on 6.
Six,
Okay,
line 1 to
sorry,
2.
the last sentence of.
I'm sorry, I didn't mean to have a
Oh, no,
sharp
that's
response.
that's fine. I was focusing on the other portions. But what about with respect to the other portions of paragraph 19?
Oh, I think I guess part of me just wanted to include everything that might be brought up on cross-examination, including this idea that, well, gee, have you spoken with other witnesses? What's been your communication with other witnesses? So that's why it's included, because those issues can tend to bear on bias one way or the other. So essentially, it's there for a complete picture to evaluate the credibility of the witness and any potential bias.
Mr. Rennie, on reconsideration, I'm sharing your concern with respect to paragraph 19, lines 25 through the end of the sentence on line 1. I do think the last sentence of paragraph 20 should be included.
I agree.
Is there dissent from the commission to sustain the objection with respect to paragraph 19, lines 25 through the end of the sentence on page 6, line 1?
And that would include sustaining an objection to Exhibit 2?
Yes. Hearing none, the objection is actually sustained. Paragraph 20. My recommendation was to overrule the objection. Does anyone have a dissenting view to that? Okay. Hearing none, the objection to paragraph 20 is overruled. Okay. I think the last issue we have with respect to the sheriff's objections, the sheriff's objections to the mayor's evidence is the video. Do I have that right?
I think that's right.
I think that's right.
Okay.
Excuse me.
We received a brief very recently from the mayor on this issue. Mr. Kopp, have you had an opportunity to review it?
Honestly, I have not. I don't recall if it came in yesterday or late the night before, but I just haven't had a chance to review it and respond.
Okay.
With respect to that, I would like the opportunity, if not to give you something in writing, then at least analyze the issue.
Mr. Keefe, do you have any objection to that?
I do. These objections were supposed to have been made, and the basis for the objection is hearsay. It's the same issues with excited utterances. I don't see how the issues are any different. One can look at the video and make that evaluation, and I think the arguments are the same that we've been making this evening about excited utterances. So I don't see a need for further briefing.
Would you stipulate to us excluding your brief then?
Well, no.
On consideration?
Of course.
Because we didn't authorize a brief either.
Well, that's true, but I don't see how counsel is handicapped in any way by not having the opportunity to brief this issue, because it's the same thing that we've been discussing with regard to the excited utterances. So, if the commission wishes to give them that opportunity, that's fine, but I don't see how the legal issues are different.
Okay. I would be inclined to provide the sheriff with an opportunity to brief the issue if he would like to, in light of when the brief came in, the mayor's brief came in. Is there a dissenting view from the commissioners.
May I ask a question of Mr. Kopp? Hasn't this issue been briefed both in the criminal aspect and in the civil motion that was filed? Whether or not the video was to be admissible?
Well, I am not sure if it was briefed in the criminal case. I know it was litigated. I don't know if there were written points and authorities. I believe there were, but not by me. Number two, with respect to the civil motion, I'm unclear as to what you're referring.
Well, wasn't there a motion brought by somebody, maybe it was brought by Ms. Lopez, to have the to have her privacy rights protected and not allow the video to be released and not allowed to be made part of the record?
I think that's correct, but I also think that's a different inquiry to its admissibility here. And so if your question is focused on the issue of have these issues been decided already such that you don't need to decide them anew, I would respectfully answer that in the negative.
Well, I'm not suggesting we don't have to decide it anew, but if in whatever brief you file, I'm suggesting that you tell us why we ought not to follow whatever rulings have been made, why this circumstance is different than was true in the previous hearings where there were attempts made to exclude this video. That's all I'm saying is that if in fact it wasn't going to be excluded in the criminal case, which has much higher standards requirement for admissibility than a proceeding such as this, I would like to see what reason there should be why we should take a position that says even though some other court has said it's admissible, we shouldn't admit it.
Well, to be candid, I'd probably be telling you that that issue was incorrectly decided. But I do feel, I mean, I understand this issue. The only reason why I asked for more time is if you were going to consider this brief that was filed by the mayor that was not pursuant to your directive. I just wanted a chance to look at what they're saying, and I haven't had that yet. If you want to strike that, I'll argue it right now.
No, I'm perfectly happy to let you file, and I appreciate that. I'm just simply saying, when you do it, address that question.
Understood.
Thank you.
And in light of the fact that it's video evidence, we're not talking about at least with respect to that piece of evidence, a person having to come in and that it could be shown at any of our hearings if it were admitted. I think that the additional time is not a problem, and I would like to give the sheriff an opportunity to brief it if he so chooses.
Well, thank you. And, you know, one other thing comes to mind. I don't know how many of the commission members may have seen it, but if the chairperson has not seen the video, I think you'd be hard-pressed to make a ruling as to its admissibility at this point in time.
And to that point, we brought a way to play the video, but I agree you need to see the video to determine whether to admit it and whether you want to review it at your leisure or here. But I do think that it's an important part of the admissibility ruling to observe the demeanor of the witness and the manner in which she speaks.
Okay, when can we see the responsive brief?
How long before the next hearing would a day or two be sufficient if we got it to you a day or two before the next hearing?
I think that would suffice.
So
Any objection from the commissioners?
I'm going to be easy on this one. That's fine.
So that would be the 26th?
Yes, that's fine.
Okay.
And just so we're clear, well, I'll file something.
Okay. If your filing says I don't need to brief it, then we'll deal with it then. In addition, it sounds that the parties would like the commissioners to review the video. My suggestion is that the commissioners do so on their own time. I don't think we need to set up whatever audiovisual we need to show it for us to evaluate whether it should be admissible, if that's acceptable to the parties and the commissioners.
That's fine with the mayor.
Yes.
And how will we get a copy of this?
I've sent
video.
7 copies to Mr. St. Croix.
You have, okay.
Or they've delivered them the other
We
morning.
have,
Delivered to us.
We have them. To our office, to our offices. Okay. Okay, it sounds like I'll be able to figure out a way to get the video. Okay. Next, we should address the mayor's objections to the declarations submitted by the sheriff. Mr. Keith, I understand that you have no objection to Mr. Tekin,
That's right.
and that's still the case?
Yes.
Okay. What about Lenny Lynn de Leon?
I have 3 objections. I think I can make them all orally.
Okay.
No. Got it?
No, I don't.
No. What it looks like. Okay, so I can share my copy with you. It's okay. So if you look in at the 5th paragraph of the Declaration of Lenny Lynn de Leon, the paragraph beginning, "I never suspected," there's a sentence 5 lines down beginning with the word "usually." We would move to exclude that for lack of foundation and that it's getting toward an expert opinion.
which paragraph is this you're referring to?
It's the paragraph beginning, "I never suspected." 5 lines down, you see the word "usually." It's that sentence.
Usually it's because,
That's right.
and then ending with no.
I guess I'm still lost.
So it begins with the paragraph, "I never suspected anything going." This is Mr. De Leon.
De Leon?
Oh, I thought you were talking about Lynette.
No.
Oh, I'm sorry. Explains it.
Was there anything else you wanted to say about that, Mr. Keith?
I've stated my objection about
Okay.
that sentence.
Mr. Kopp, do you have a response?
Only that the foundation appears to have been laid previously when she describes her experience in caring for children. I'm sorry, experience in caring for children.
Any questions for Mr. Kopp or Mr. Keith on this?
Mr. Kopp, when you say she described her experience in caring for children, are you talking about just the first sentence?
Where she says she's a child care provider and not, so it's implied that it's not just for Sheriff Mirkarimi and Ms. Lopez's son, and then she talks about having provided child care to him as well.
I'd be inclined to sustain the objection. I think it's, I do think it lacks foundation and would be more appropriate for expert testimony if it were relevant. Is there a dissenting view with respect to that objection?
What are the lines that you're, or what are you,
The
whole paragraph?
No, the line that begins, usually it's because children have,
okay.
and ends with that
I
sentence.
understand.
Hearing no dissent, the objection is sustained. You said you had two others, Mr. Keith?
Yes, relevance objections. The next full paragraph after that beginning, when they were separated, we objected that on relevance grounds. It's basically a lot of statements about the observations of the child's behavior after the sheriff was arrested and the stay-away order served on January 13th.
Mr. Kopp?
I'll just submit on that.
Okay. I would be inclined to sustain the objection. I don't see how it's relevant to the task we have. Are there dissenting views among the commissioners? Hearing none, the objection is sustained. What is the last objection to this, Mr. Keith?
On the second page, the paragraph beginning, Theo began. That paragraph through the end of the declaration, we would object to on relevance grounds for the same reasons. So it concerns the child's behavior after the sheriff received the stay-away order, and as well as the witness's own feelings and thoughts and observations about the family, which don't seem to be relevant.
Mr. Kopp?
I'll submit on that.
I would be inclined to sustain the objection on relevance grounds. Is there a dissenting view? Okay, the objection is sustained. The remainder of Mr. De Leon's testimony will be admitted. Okay, Ms. Haynes. You submitted written objections, Mr. Keith. We'll deal with those, and are there any others that we need to deal with? Okay. So why don't we hear from Mr. Kopp then, since your objections are stated.
As to the first objection dealing with the statement in the second paragraph, I would argue that the foundation was indeed shown for this statement, if indeed it is a lay opinion, by the previous sentence in which she states she has training regarding domestic violence. But moreover, I don't believe that this is really an expert opinion. It appears to communicate Ms. Peralta Haynes's belief that she didn't have to do anything affirmative, that for herself she was satisfied that Ms. Lopez was not in any danger. I don't think she's trying to say by this that this is an empirical fact. Ms. Lopez was not in danger. This is just her own perception.
Mr. Keith, do you have any response to that?
If this is only offered to show why, Ms. Lopez's state of mind and why she decided to do whatever she did next, then we don't have an objection to it being offered for that purpose. We do have an objection to it being offered to, essentially as the assessment of a professional about whether she was actually in danger.
I would be inclined to overrule this objection. I don't think this is being offered as an expert. I think it's being offered as her opinion. What probative value that has, I think there's some, but
I would add we're not given any of the facts on which she relied. All we're given is that she spoke with her, but we get none of the information on which she's relied, and of course whatever she relied on would be hearsay. So,
well, she has her own experience. She's not stating she's an expert. I would be inclined to allow it. Dissenting views from the commissioners or questions from Mr. Keith or Mr. Kopp? Okay, the objection is overruled. Mr. Kopp, do you want to address the second objection?
Yes, as in the third paragraph, I believe that the portion that's being objected to is the italicized portion. The woman responded no. And I would agree that that could not come in for a hearsay purpose, that is, to show that this woman on the phone had not contacted any domestic violence agencies or tried to connect Eliana with them. But it could come in for a non-hearsay purpose of, first of all, contextualizing the entire conversation between that woman and Ms. Haynes, and second of all, explaining why Ms. Haynes said what she said thereafter.
Mr. Keith?
Well, I think as the main basis for the objection, the other side concedes that this can't be shown for the truth of the matter. I have my doubts about what kind of context it gives, because the next speaker there was Ms. Madison, not Ms. Haynes. So I don't think it really serves even a non-hearsay purpose.
I'd be inclined to overrule this objection. Same caveat as with all of these with respect to the actual value of hearsay, but this is a conversation that is going to be, I think, that is clearly at issue between Ms. Haynes and Ms. Madison, and I think I'd be inclined to allow it. Any dissenting view from the commissioners? That objection is overruled. The third objection, Mr. Kopp.
Yes, and I concede that this cannot come in for the hearsay purpose of showing that Ms. Lopez had not been able to contact the sheriff up to that point in time. But I think when the sentence is read in its entirety, the only fair import is that it explains why Ms. Peralta Haynes called Ross Mirkarimi. She says, I called him because, and then goes on with the portion that they're objecting to. So we don't seek to admit it for that hearsay purpose.
And for our part, we don't object to the statement that Ms. Lopez urged her to make the call, because that, in fact, explains why she made the call. What we do object to is this additional information from Ms. Lopez about what she had been doing. That's hearsay and inadmissible, and I don't think there's any other evidence in the record, at least not at this point, that would be a hook for that to come in under administrative hearsay.
I'd solicit the views of my fellow commissioners on this objection.
Well, I think that if we've allowed the other, hearsay evidence to come in under the same caveat, we should allow this as well from the sheriff's side.
I'd be inclined to overrule the objection then. Any dissent from the commissioners? Yeah, that objection is overruled. Okay. The sheriff's declaration. Let's give us a moment here.
Before we leave, Ms. Haynes, I take it she's going to, a subpoena's been issued for her?
A subpoena has been issued for her. It sounds like she is saying she is not available until July. We can talk about, I think we should discuss scheduling as well as soon as we're done with this, but we should address when she's going to be able to testify. Okay. The objections to the sheriff's declaration. I think we have the objections. Is there anything else we need to consider, Mr. Keith?
No.
Okay. Mr. Kopp, will you be addressing this?
Perhaps I misunderstood or missed something, but I didn't see objections to his specific statements in the declaration. I thought they merely intended to cross-examine him.
The sheriff had filed his declaration late, and so we filed our objections.
If I can just have a moment, please. Yeah, no, you got it. Okay, I'm ready.
Okay. The first objection.
Well, I don't think this is an opinion. It's a statement of fact. And he was there when they were dropped, so, yeah, I think he can offer this testimony.
Mr. Keith, is
charge-
this really disputed, though?
The charges were dismissed under Section 1385 as part of a global plea bargain. That's in my mind, that's different from charges being dropped, and I think there's a distinction. But
Okay.
no, and I don't think. I mean, I think the records of the conviction and the what happened at the sentencing speak for themselves, and this interjects some unneeded ambiguity into what occurred.
My inclination would be to overrule the objection and allow Mr. Keith to handle it during cross-examination. Any dissenting view? Okay, that objection is overruled. The second objection?
Yes. In terms of the mayor not ever telling Sheriff Mirkarimi why he suspended him, we think it is relevant. If there wasn't a legally valid reason for the suspension, but rather was an improper reason for the suspension, that could go to the mayor's bias.
Mr. Keith?
This is not our objection on this was relevant, and I mean there's not a due process claim before the commission about whether there's a property interest in getting paid or anything like that. So this simply isn't relevant. The extent of the communications with the mayor and the nature of the communications, even if it may go to the mayor's bias, you know, does the sheriff think the mayor was unfair? Well, plainly he does. But I don't think that it undermines or weighs one way or the other regarding the validity of the charges. The charges rise and fall on the facts. They don't rise on what was going on in the mayor's head.
Can I ask you, Mr. Keith, then, what is the purpose of the mayor's declaration?
One was requested.
Please,
Yeah.
if we could keep. I mean, you submitted a declaration, and the mayor basically said why he issued the charges, and it talks about his decision. So it does seem to me that there is potentially some relevance to what, I mean, you put at issue the basis of the decision, and I for one, think that the sheriff should be permitted to examine the mayor on whether that really was the basis, and not being told of what the charges are, I think, is potentially relevant to that state of mind.
Well, number one, we do dispute the facts of what happened in the conversation between the mayor and the sheriff. But putting that aside for a moment, we submitted a declaration from the mayor because we were requested to by the commission, and we thought the commission wanted to know what the mayor's reasons were for bringing the charges. Strictly speaking, his reasons aren't important, but he does have some personal knowledge of what is expected of a public official and the standards that they have to hold to. So his declaration is relevant to that extent. Why the particular things that motivated him, I don't think those are relevant.
Well, first of all, and I've been wrong before, but my understanding was that he was on your witness list, and we thought that based on the statements that were provided for what the witnesses would say, that he would be relevant. So
we put him on our witness list after the commission indicated they wanted to hear from them, and I may be wrong too, but certainly that was our feeling was the commission indicated they wanted to hear from the mayor. We're going to put him on our list. I mean, it was as simple as that. I mean, this issue of whether the mayor told the sheriff why, I still don't see how that even gets to the issue of bias.
Well, I mean, in paragraph 4 of the mayor's declaration, it says, I decided, based on Sheriff Mirkarimi's conduct, crime, conviction, and sentence, that he committed official misconduct and was not fit to hold the office. And then in paragraph 6, that he decided that immediate action was necessary. I mean, he seems to have put at issue his reasoning for why he issued the charges.
I don't think the mayor submitting a declaration about the exact reasons that motivated him to file the charges puts at issue the mayor's motivation on the issue of what happened with regard to official misconduct. What I do think it does is it says this is the judgment of the mayor about why this conduct is serious. But again, I think that there's a difference here. I mean, what's motivating the mayor versus his judgment that the conduct is serious, I think, is a different issue. And again, we're trying to provide the commission with what it wanted, and this is what the mayor has to give on this issue, is what he did and why he did it. I mean, sort of putting aside for a moment what the ultimate relevance issues are.
Have I missed something? Aren't we on line, paragraph 19 of the declaration?
Yes,
And that is if somebody asks the question of the mayor or the sheriff, one or the other, did the mayor tell you why he was suspending you? There'd be no objection to that question. The answer would be yes or no. There's nothing objectionable about it. So I don't understand. I guess I don't understand why we're spending any time on it. It's clearly a statement of fact which a live witness could be asked about in any court of law, and there'd be no objection.
Well, certainly the mayor has personal knowledge. I mean, he's got foundation, but just on the issue of relevance, on this issue of what happened in terms of the back and forth between the two of them before the sheriff was actually suspended, that our argument is that specifically isn't relevant.
Well, there may be a lot of irrelevancies, but it's not an objectionable statement.
Well, I mean, Mr. Ernie, I think we have been excluding things based on relevance.
We have, but those are things that go to sort of the substance. But clearly, if the witness were here and the attorney asked him the question, did the mayor tell you why he was suspending you? And somebody objected, I'd shake my head and say, he can answer yes or no. Nothing to do with relevance. But
I think I understand.
Okay, well, I think I know where Mr. Rennie falls on this objection. I actually, too, think it should be overruled, as I probably indicated from my questioning as well. Is there a dissenting view from the commission as to whether that line should be permitted?
No, I mean, I think at the very least it could come in as background foundational evidence. I don't see any problem with it coming in.
Okay, that objection is overruled. Line 20, paragraph 20, line 1.
This is also relevant to that same issue, whether or not the mayor had some kind of bias in his decision, but it is also relevant to the issue of whether or not there was an adequate investigation done here by the mayor before the charges of official misconduct were filed. And as I believe has been made clear throughout the course of these proceedings, the investigation was not only not concluded, it wasn't really even begun at the time the charges were filed. So for those reasons, we believe the mayor's failure to talk to the sheriff or his wife about what happened is highly relevant.
Mr. Keith?
I think, I mean, I hate to retread ground we've been on, but the mayor made this decision when he found out that the sheriff is a convict and he's on probation for 3 years of his term. That's when the mayor made this decision. The idea that the mayor needs to conduct a further investigation after that point before he can file charges is not a defense to whether or not somebody committed official misconduct.
Okay. Please, we are nearing the end of this proceeding. I think the public has been very respectful thus far, and we really would like that to continue. So please, none of the extracurricular conversation. Thank you.
So having made that point, I see where the arguments that we just made regarding the last objection, where they're going to lead. So I'll just assume the commission has already heard those and let the commission make its ruling.
My view is that whether or not the mayor told the sheriff's wife is not relevant or probative of anything. I don't see a situation in which that would happen. In any event, I don't see the relevance or the probative value of that. So I would strike or my wife and permit the remainder. Is there a dissenting view to that? Hearing none, the objection is sustained as to or my wife and overruled as to the remainder of paragraph 20. Paragraph 21.
Well, I don't see this as the sheriff's opinion that he has present ability to, I mean, it's really just a phrase that is uttered routinely. So I don't see this as his expert opinion that he has the ability to serve as a chief law enforcement officer, but I don't think I have any further comment besides that.
If that's a limitation, we'll stipulate to that limitation.
Sounds like there's a stipulation. The objection is overruled, unless there's dissenting views from the commission. Okay. Have we now handled all of the witness declarations from the sheriff?
I believe so.
Yes.
Okay, let's talk about the schedule. We currently have available to us the 28th of June in the evening and the 29th of June. Based on my conversations with counsel during the break, it sounds like the counsel agree that live testimony should begin not today, but on the 28th. Do I have that correct?
Yes.
Yes.
So on the 28th, we will hear, I believe the mayor said he was going to call the sheriff. Do I have that right?
We will definitely have a witness on the 28th.
Okay.
I don't know whether it's going to be the sheriff because I want to make sure that if it's, I'm sorry. I don't know whether it's going to be the sheriff because I want to make sure that we don't have a witness who can only come on the 28th. And I don't know about that, but we will certainly have a witness. It will be the sheriff if no one else.
Okay. Well, you know what? Before we get to there, let's identify so that we all are clear on which witnesses we currently know we will see live. So that would be the sheriff, recipient witnesses, the sheriff, the mayor, and Ms. Haynes. Is there anybody else that I've missed who we know with certainty right now that we will hear live?
I don't think so.
I don't think so.
Okay, so then what recipient witness would, other than the sheriff, would? Are you saying the mayor may?
No, now looking at this list, both of our experts are available on the 29th, and if we're going to have rulings on experts on the 28th,
okay.
I think it makes sense to have the sheriff on the 28th.
Okay, and is that acceptable to defense counsel?
Well, I had thought so, but an issue just came up. If I can just have a minute. I just need a moment, please. Yes, so that's fine, although I should state our objection to the sheriff testifying before the mayor's witnesses, which probably would be the mayor.
My understanding is that the mayor intends to call the sheriff in his case.
I understand that, but I just
okay, but you want to make an objection to that? Okay.
Yes.
Okay.
But he should be ready and available on
Okay.
the 28th.
Great. And I understand the mayor, based on our previous scheduling conversations, is available on the 29th?
That's correct.
So in addition, on the 29th, we had discussed, as a scheduling matter, the possibility of experts testifying out of order, meaning having experts testify on the 29th and then having other recipient witnesses testify thereafter. And it sounds like the parties agree that that would be okay with them. Do I have that correct?
That's right, though there may be no need to take them out of order if it's the mayor and then the mayor's 2 expert witnesses. That may take up the bulk of the 29th.
Well, you still want Haynes, right?
Yes, but then I don't know about the availability of the expert witness, and nor do I even know whether we want to cross-examine him. We're still deciding that.
Oh, I see.
Yeah.
Okay.
I don't know about the availability of their expert witness.
I don't have an answer. If you, on ex-Sheriff Hennessy, I don't know if he's available 28th or 29th. I was waiting, so I need an indication as to whether or not they intend to cross-examine him and want him to appear.
Yeah. And we agreed to exchange those indications on Thursday.
Okay. I would, I think we do need to hear from any experts that we have on the 29th. And so I thought that's what we had discussed, and I thought we were also going to get an indication that all the experts were available on the 29th.
Ours are.
Yours are.
Yeah.
I can find out in short order about ex-Sheriff Hennessy.
Okay.
And again, depending, I still haven't had a chance to fully digest or even read in its entirety the 2 expert witness declarations submitted by the mayor, but depending on if we have objections, if they're sustained or not, we may not require them to appear for cross.
Understood. Okay, so then my understanding is that on the 28th, we will deal with objections to any experts, further objections to Ms. Madison, further objections to Mr. Mertens, and potentially the testimony of the sheriff on the 28th.
Exhibit 4.
And Exhibit 4, the video. I assume it's no problem for the sheriff to testify on the 29th if, for some reason, we run out of time on the 28th.
He'll be available.
Okay.
So, Commissioner, just from a logistical standpoint, getting our experts up here on the 29th without knowing whether or not they have to be up here is difficult.
Okay.
I guess we'll know on the 22nd whether the sheriff wants to cross-examine the experts, but then we would need to know whether the commission wants to hear from them, because I know that they start to have availability problems in July. The experts do.
Well, why don't we plan to have them here?
Okay.
And then that's really what I thought was going to happen, that the experts were going to be available, and if you didn't want to cross them, then they wouldn't need to appear. Or if the commission wanted to ask a question, then they would be here for those questions, but that otherwise we'd be able to make that decision on the 28th when we see all the papers.
So I guess one of them has to travel. Chief Lansdowne has to travel from San Diego, so we'll just make the travel plans as if he's going to be here.
Well, he's coming on the 28th.
Oh, yeah, he'll have to come on the 28th for that, so.
Mr. Lansdowne is not available on the 29th. He's only available on the 28th.
I'm sorry, he's not available on the 28th, but he has to travel on the 28th.
My concern is twofold for Chief Lansdowne. First of all, he's a chief of police, and so being away from his position for 2 days if he's not actually going to be asked to testify is burdensome for him. And it's also the case that it's burdensome for the city to pay for that travel if his testimony isn't going to be needed. I was wondering if perhaps there would be a way in advance of the 28th to know whether, we know that Sheriff Mirkarimi will indicate whether he has interest in cross-examining, but I'm wondering if there's any procedure whereby any of the commissioners could indicate their interest so that if there is no need for him to appear, we won't have to bring him up here for the reasons of the burden to him and the burden to the city.
I am not aware of a procedure by which we could accomplish that if it required polling all of the commissioners. One thing that comes to mind is we could designate a commissioner to make that decision. But beyond that, unless we had a meeting just to address that issue, I can't think of a way to make that happen consistent with our obligations under Sunshine and the Brown Act. I welcome our other views and our legal advice.
Isn't it that each of us can look at the declarations and then make a decision, and I could call Mr. Embledge, or I could call you and say, I don't care to cross-examine them, and individually, we're not conferring with each other. We're just simply saying what our desire is. Can't we do that?
If the indication to council would be that any one commissioner expresses a desire for Mr. Lansdowne to testify, then I would be open to receiving calls from any commissioner who has that intention, and I could communicate that by the 22nd to council. The commissioners should not confer among themselves, however.
Right.
Mr. St. Croix, do you have any?
No, that would be fine. You can't discuss this amongst yourselves. You can poll the commission so that each commissioner can relate to Mr. Embledge, yes or no, and then you can decide if any of you want it, then you're going to do it, or if a majority of you want it, then you're going to do it.
If, just solely for my purposes, if this is related to both of the expert witnesses, and you didn't raise about the second one, I'd be able to do it by the night of the 22nd, but not sooner than that.
It would, of course, be helpful, I'm sure, for both of our expert witnesses to know if they need to appear and testify. The travel is not an issue for Ms. Lemon. She actually lives in the Bay Area.
Okay, well, why don't we?
It might be for planning purposes.
But it would be very helpful, I'm sure, if she had some advance notice.
Why don't we let you know? Okay, and so we're all in agreement that that is consistent with our Sunshine and Brown Act obligations. Brown Act obligations. Yes.
I do have a problem with polling the commission, but again, I think the procedure whereby commissioners express an interest to me, and we agree that if a commissioner wants that testimony, I can pass that on to counsel for both sides. I think that works.
Okay, so then the procedure would be that if any one commissioner wanted to hear from an expert, that expert would be asked to appear. Okay, and if we let you know that by, the 22nd is a Friday, by the 25th, is that sufficient? Because by the 22nd, you will know whether you all will be bringing them anyway, right? So I don't think it makes sense to hear from the commission before then.
I'm sure that my witnesses would tell you the sooner the better.
Okay.
But, please do it as you see fit.
Okay.
And I'm also wondering with this.
2 o'clock Friday, if that's any help.
I'm also wondering maybe we should also do it this way for former Sheriff Hennessy, just so all the experts are on notice of what's going to happen. Just a suggestion.
And just as a
So, yes, I think that's right. We should weigh in on all the experts. I'm sorry, Ms.
I was just going to add, for Mr. Embledge's purposes, once he has one, doesn't matter when the others respond, he could just advise us that expert will appear.
That's fine.
Right? That way we would.
Right.
We wouldn't have to rush to review the material if the weekend was better or something like that.
Okay. Well, why don't we put a deadline, though, so that commissioners need to respond by
Right.
5 o'clock on the 25th?
22nd?
No,
25th?
Well, the 22nd is when you all will tell each other when
I
mean,
was
that's fine.
hoping we could
That's-
also hear from the commission by then. Just for the, again, I'm just advocating for the convenience of my witnesses.
No, I can do it by the
By that time
end of the
20
plane flight on Friday. I can do it.
Okay. Okay, so 5 p.m. on the 22nd, the commissioners will tell Mr. Embledge whether they want to hear from an expert.
Thank you very much.
Okay.
By the way, the police chief coming from San Diego doesn't need to come the night before. He can come in the morning. And I mean, San Diego is not a tough place. People do it every day.
I understand, but I know you're a practicing lawyer as well, and you probably prepare witnesses before they testify. So we're going to need just a little time to consult with the chief.
All right.
Okay. On the 28th, we may hear from the sheriff. We will certainly hear from him by the 29th. On the 29th, we will hear from the mayor and from any other experts. We then need a date to hear testimony from Ms. Haynes, and I think we should, and whatever that date is, we would hope that we can get Mr. Mertens and Ms. Madison to the extent they need to be cross-examined. So, Mr. Kopp?
I was just going to say, based on some conflicts among lawyers, I think the earliest we'd be able to do that would be July 16th. Is that?
And I'm sorry, the commissioners have, I just got this schedule. Is July 16th available for all of the commissioners?
Is that on Monday?
That is Monday,
is-
July 16th.
It is not.
Okay. I guess this is a question of the commission staff. I'm sorry.
That's okay.
I think this is a question of the commission staff. There are no rooms available from the 17th to the 20th?
It's possible that this room is available in the evening, but we have to double-check the schedules of who's meeting during the day, and also with SGTV to see if they have broadcast slots available, too. But for those evenings, if you wish to meet on those, we can schedule them tentatively, and hopefully they stay together. I would recommend doing that.
Right. Mr. Kopp, you look like you wanted to say something.
Well, I just wanted to ask, are weekends out?
Yeah, unfortunately, the building is closed on weekends.
Because in Missoula, they were there on a Sunday.
Probably wasn't July.
And then we also have reservations on the 20th, 23rd, 24th, and 27th, and 30th.
Okay, so the 20th will not work after all. It does not look like the 23rd is going to work. So here's what I propose. I propose, and I want this to be clear on the record, that council and the council reserve the 17th through the 19th. But we need to make sure that actually that the commissioners can make that. Between the 17th and the 19th, are commissioners available on any of those dates, 17th, 18th, or 19th?
I'll need to check the 17th. The 18th and 19th are okay.
The 18th and 19th are okay, okay. So why don't we have everyone, for the moment, block out on their calendars the 18th and the 19th as potential days? Does that work for council?
Yes. Yes.
Okay.
I'm sorry, excuse me. Are you talking during the day or in the evening?
Evening.
Evening.
There isn't any time when we can do a full day and hopefully get it done in one sitting?
Not on those dates.
And you're releasing the 20th?
I am releasing the 20th. 23rd, I think, is unavailable because of other unavailability. It looks like we have the 24th of July as a possibility for an all-day.
That's available all day.
My phone expired, so I can't tell.
Council, July 24th, is that?
I'm supposed to start a trial the day before. It could easily resolve. I can try to continue that case so we can get this done. I'm assuming that this is if the 18th and 19th are not available.
Is there a conflict with the evening of the 18th and 19th among commissioners?
No.
I can move what I have.
Okay, apologies for the difficulty here.
Commissioner, if I'm the only problem on the 23rd, I can adjust that.
Okay. Thank you, Mr. Emlich. We appreciate that. Is the 23rd available for? No.
That's what I'm supposed to.
That's when the trial is supposed to start.
And even if it does get resolved, I'm going to have to be there to resolve it. So that's why, if we have to go past the 18th, 19th, the 24th will be better. I'll just have to file a motion to continue the case.
Okay, I think we should leave open the evening of the 18th and the 19th. It's possible that on that day we'll have one witness. It's possible we'll have up to 3, but I don't see a situation where we have more than 3 witnesses. Is that fair?
Yes.
Yeah.
So I don't think we'd need both those days. I think we could get it done in one evening, would be my expectation. It's just cross. I guess with Madison and Merton, there's a possibility there's some direct, but again, you look skeptical.
I'm not skeptical.
No. I think we may be able to resolve the objections, and we'll see.
Okay. So if people could block out the evening of the 18th and the 19th, we will hopefully need only one and hopefully be able to finish the testimony by that time.
But not the 17th.
The 17th, it sounds like there's some commissioner potential unavailability, so.
I should be able to let you know by tomorrow.
Okay. And perhaps we should do another scheduling call shortly to actually nail down these dates. Okay. Any objections to the July 17th to 19th, or 18th or 19th as another hearing date, assuming we can get Ms. Haynes here one of those days?
No.
No.
Okay. Another
Chairman.
thing. Yes.
Sorry. Shouldn't we, just in case, lock down the 24th if we can?
The 24th, Mr. Kopp may be in trial, so I'm reluctant to schedule it. He's going to be in. Certainly, if your case resolves shortly, it might be helpful to have that available. But as of now, I don't think we should.
I'll see if I
schedule
can.
it for then.
I'll see if I can figure that out and report back to Council and Mr. Emlich.
Okay. I'm sorry. Exhibit lists. So, did you all exchange exhibit lists today?
We prepared it. We had some technical difficulties filing, so it should still be filed
Okay.
today.
So you all will get copies of your respective exhibit lists. We've made rulings today that affect probably a number of the exhibits. Do you want to resubmit exhibit lists tomorrow in light of our rulings today?
I think maybe just a notation, just the same exhibit list with a notation of what the ruling was, just would make sense.
Okay.
As a record of what we have.
Mr. Wagner, what do you? What are your views on that?
We'd like to have until Wednesday. We're in the process of compiling the exhibit list based in part in response of the recent receipt of the declarations from Mr. Mertens and Ms. Madison.
Okay, who would be the sponsoring witness of these exhibits?
Well, they're voluminous, so I can't tell you off the top of my head.
Okay, can you describe the nature of these exhibits? What are they?
Some of them are transcripts of interviews with Ms. Madison and Ms. Madison and Mr. Mertens, police interviews with those individuals. There's also a transcript of an interview with Ms. Williams. There are also other documents that we would like to submit relevant to the sheriff's declaration. There are documents we would like to submit relevant to nearly all of the declarations, but I don't have them. There's many of them, and I don't have them all memorized and ready to go immediately, but I think I could have them by Wednesday.
Oh, I thought that you all were exchanging exhibit lists today. I'll give you to the close of business tomorrow to exchange them with whatever notations you want. But I think the parties need to exchange so that you all can submit whatever objections you may have to documents and get them to us so that we can see them by the 28th. I expected, and I think the commission agreed with me that we expected to see all documents that you intended to introduce in your case in chief with your declarations. Now, if you're talking about rebuttal exhibits or exhibits that you would use to impeach a witness, to me at least, I don't think those need to be on an exhibit list. Welcome the views of my fellow commissioners, but if that, and it sounds like that may be the type of evidence you're talking about, Mr. Wagner.
To some extent, that's true. There may be some exhibits that we would wish to submit for impeachment purposes without necessarily calling the witness to cross-examine the witness. And
you want to introduce an exhibit to impeach a witness who's not here to testify, to be cross-examined?
I'm not saying we definitely want to do that. I'm holding that out as a possibility. Given that the strict rules of evidence do not apply, and you've admitted a great deal of hearsay, for example, this evening, we would also have exhibits in mind that we would like to submit. And in the interest of time, it may not make sense to cross-examine the witness per se. On the other hand, there may be exhibits, for example, transcripts of interviews that may be probative for your deliberations. And at that point, you could give them, just as the other exhibits and testimony that you've admitted into evidence or will admit, give them the weight that you think they deserve.
That's not what I had in mind for how the exhibits would work. I know we have a number of litigators on this, and we all have our views, I think. So I'd welcome the thoughts of my fellow commissioners.
Well, I guess what I had anticipated is that each side would supply the other with a list of the exhibits they intend to put in, and if there are any foundation objections, those should be lodged, but hopefully there won't be, or there will be very few. And then the question is whether or not the document is admissible without any testimony. And again, you may have agreement on that, but if you don't, then those documents can be identified and presented to us, and we can rule on them whenever you want to put them in. But you can have alerted us at the beginning of those where there's no foundation, no challenge to the foundation of the document, and the only challenge goes to whether or not they're admissible for whatever reasons there might be an objection. And if those are all going to be used in connection with the presentation of a witness, that's one way to do it. The other way is to do it just simply by saying these are offering them when you're case in chief.
That's my understanding. Thank you, Commissioner.
Any other views with respect to the admission of documentary evidence?
I mean, I did expect, I know the rules of evidence were being very relaxed here, but I did expect sponsoring witness with exhibits unless there was a stipulation of some sort. So when you say you have transcripts of interviews, what are you referring to?
Mr. Madison, or excuse me, Ms. Madison and Mr. Mertens and Ms. Williams were all interviewed by the police. There's transcripts of those interviews. Just similarly to the transcripts of the, well, it's not similar at all, but it's, you earlier admitted the court transcripts from Ms. Flores' testimony.
Well, I think we had reserved on that, but that's sworn testimony, correct?
Yes. I mean, you don't have to admit that, similar to, what Commissioner Rennie said, or precisely what Commissioner Rennie said, you don't have to admit them. I mean, but we do intend to submit them, and then you can make a decision whether or not you want to admit them as admissible.
Would we, under your scenario, would we get them in time to allow us to have the witness in person to reconcile the documentary offer or the previous interview transcript with live testimony on cross about it? I mean, if it came in late in the process, that might be difficult, but if we knew that that was coming early on, it might signal that we in fact wanted certain witnesses available. Or we might feel that it didn't trigger that and that it was reconcilable without them.
I'm not sure the question that you asked, Commissioner, but I can say that I will get the opposing party and the Commission our exhibit list by the close of business tomorrow.
That would be great. And if we could have objections by the end of Friday, is that possible?
These folks must not be sleeping. Unbelievable.
I'm a little confused, frankly, and I'm just seeking clarification. In the scheduling conversations we had with Mr. Embledge and Commissioner Herr, we had discussed altogether submitting exhibits, and we had talked about a procedure whereby by today, both sides would submit the exhibits that did not come in through a declaration. So that's what we've been prepared to submit today, and we only have 4 submissions. We've given you our evidence with our declarations. So it's unclear to me now if there's a whole new process where we're starting with objections to everybody's documents as if we hadn't been already doing this. I mean, are we just talking about this subset of documents that we had all agreed to, or is the door wide open again? I don't understand.
So my understanding was that any documentary evidence that was not submitted with a declaration that you intended to use would be included on this exhibit list that would be exchanged today. I'm proposing that we extend the deadline to tomorrow because it sounds like there were some technical difficulties on your end. It sounds like Mr. Wagner had some difficulties on his end. You had mentioned some telephone records that needed redacting. I mean, maybe perhaps that can all be done and we can have these lists in a complete form by the end of the day tomorrow. That is my point. And then by Friday, I would like to see, or Monday if that's too soon, but the process that we were discussing, that I thought we were discussing, was that you would meet and confer, you would stipulate to those documents to which there was no objection, and if there were objections, that they would then be submitted so that we would be able to rule on them by the 28th.
Is the Commission going to entertain objections to documents that are attached to declarations that you've already reviewed? Or is that topic closed now?
Okay, so if we have, for example, if we have sustained an objection to a paragraph that includes an exhibit, that document is out.
And will there be a second chance to object to other exhibits in the same declaration that's already been considered?
I was not anticipating that, no. And I don't.
Thank you.
I think we're all talking about the same thing, but please
I just
let me
want to
know
be
if we're
clear.
not.
Thank you. I'm not in any way criticizing. It's just difficult to get clarity later if I don't have it today. So that's all.
That's fine. And what we will do, like we did last time, is endeavor to issue a press release that summarizes all our decisions today.
And then, Commissioner, there is one documentary submission which we gave notice of in the list that we're submitting, and that is that we will ultimately be submitting some of Sheriff Mirkarimi's public statements under the party admission rule. But I want to wait until Sheriff Mirkarimi testifies, because our submission after he testifies will be a lot smaller than it would be if it were before he testifies. That is, if he's going to testify here to facts, I don't want to. There's no need to submit public statements that reflect those facts. So, but what I would like to do on our part is to wait until after he's testified to submit those admissions.
Why don't I allow Mr. Kopp or Mr. Wagner to address that?
That's fine with us.
Okay. That being the case, that's fine by stipulation. Mr. Rennie, was there something?
I just want a question of clarification. As I understand it, the sheriff is going to be called by you in your case in chief. Is it agreeable, Mr. Kopp, that you or whoever counsel is handling it will then put on whatever direct you want with him, or are you going to wait and put him on when you bring your case on?
No, we'll do it at the same time.
Okay.
Yeah.
Good.
In that case, we would allow the redirect. We'd probably allow some leeway on the redirect, on the scope.
The objections to the exhibits that will be submitted by the end of the day tomorrow are due when?
The objections to those, I think, should be due by Monday, 25th. And again, the point is to give you guys a chance to stipulate where stipulation is appropriate, so that we don't have to deal with an objection to every single exhibit. Is that acceptable to the Commission? Okay, anything else that we need to deal with?
Not on our part. Thank you.
No, not for us.
Mr. Embledge, anything?
I don't think so.
Commissioners?
No, nothing.
Do we need a motion to adopt the interim decisions that we made throughout the evening?
It's your custom. You don't need it, but you usually do it.
Okay. Is there a motion to adopt the evidentiary and scheduling decisions that the Commission has made throughout the course of the evening?
So moved.
Is there a second? Second. All in favor?
Aye.
Opposed? There being none? Okay, adjourn. Meeting is adjourned.